Your Lordship, I represent a 4-year-old child, Your Lordship, and it had to go for renewal of the passport, and the passport officer has denied on the basis of objection received from the husband, who is estranged and living separately with the mother. I would kindly consider ask you to consider the case. I have already served the copies to other parties. It is already listed for today. You would have to kindly give a date any time.
Listed for today means?
It's in a new motion, Your
Yes.
Lordship.
It will appear in the list. It is appearing, it will appear. Where is the difficulty?
I beg your pardon, Your Lordship.
The matter is there in the list.
Yeah, it is in as a new motion. It's 160 in new motion, Your Lordship.
So it's all right. Let it remain. What do you want?
But will it come, Your Lordship? 160, I've seen that it doesn't reach up to that level at all.
No, it usually doesn't, and it will not, because there are other matters in the combined list. Your matter will be there in the combined list on Monday. Please mention so that it can be upgraded.
Okay. Grateful, Your Lordship.
Praying for grant of leave. The extreme urgency is the petitioner is enjoying patta over his land granted by the government. Now, the contractors of the chief medical officer health they are entering into my plot, digging up the land, dumping construction materials in order to construct a primary health center since the last 5 days. Extremely urgent, my lord. I have requested them. I have sent representation. They are not accepting. They're continuing with it.
You file it in the department. Give the number.
If any date can be fixed, my lord.
You give the number. I'll see. Construction cannot be over in a day. You serve. Come back. I'll check up. Yes.
My lord, I am praying leave for filing a contempt application. Order passed by Lordship at circuit bench, and this is a contempt application now.
Which circuit?
Jalpaiguri circuit bench.
Yes.
So, my lord, without leave, my lord, department is not accepting to file the contempt application.
Where will leave?
My lord, there is an extreme urgent tender matter. My lord, I cannot wait, my lord, till Monday. My lord, it has to be moved by 2 p.m. today, because, my lord, yesterday 3:45 p.m. my lord, financial bid has been opened. Now the issue remains, my lord, since 23rd June, my lord, we are raising the objections, and that has not been considered. Initially it was considered, and again, my lord, the financial bid has been opened, indicating all the categories, wherefrom it will be reflected that it's completely biased. My lord, if I can satisfy your lordship, my lord,
which authority?
My lord, the authority of Panchayat Rural Development Authority, my lord, under the government of West Bengal. My lord, there are, my lord, the authorities, state respondents, I can serve.
You have to serve, or you
my lord, I want to move it by 2 p.m. my lord, because, my lord, the only reason is this, my lord, it shows that yesterday 3:45 p.m. my lord, the financial bid has been opened. Although since 23rd June, my lord, they indicated that the financial bid will be opened. That has not been opened. Yesterday at 3:45 p.m. my lord, in spite of having repeated objections from every corner.
See, today and Monday will not make much of a difference. If the court will see that there is some error, court can always set it aside.
My lord, the issue remains, my lord, if, my lord, the work order is issued, then, my lord, I will be in great difficulty. If I can satisfy your lordship, my lord, at 2 p.m. my lord, so that, my lord, only one interim order.
Absence of the other side.
My lord, I shall serve. My lord, there is a mail ID. My lord, I shall serve.
Mail ID, somebody has to come and represent. Somebody has to obtain instruction. You take the number. Monday urgent motion it will appear. In the meantime, serve. Let's see.
My lord.
Yes.
My lord, contempt application. My lord, Kolkata Municipal
Court. No, do not. You want for inclusion?
Inclusion.
Monday.
With your lordship's leave, my lord, this matter, my lord, was pleased to pass an order against an insurance company, my lord, to provide the petitioner certain documents relating, my lord, to a survey report. My lord, that pertain to a different policy. And, my lord, a similar matter with, my lord, a similar policy and a similar document sought for, my lord, has not appeared in the list. My lord, an identical order needs to be passed in that matter as well, so that, my lord, they can comply both the survey reports together.
Monday.
Should I mention, my lord?
Call the list.
My lord, this is the appellate side matter, my lord. For correction, my lord.
What is the correction?
My lord,
yes.
My lord, matter is disposed of, but, yes, my lord, in typographical is dismissed. This is the my status report already. And also live streaming, my lord also held that disposed, my lord. This is typographical mistake.
It will be dismissed.
My lord, my lord, kindly live streaming.
I have
Yeah.
checked up in case there is some error at the time of dictation also, but this is dismissed because no order was passed in your favor.
No, my lord.
You did not get any relief. If the writ petition fails, so it is always a dismissal.
My lord.
All right. So whatever is there, it is all right. Yes.
I'm appearing for the petitioner's bullets. I'm praying for an accommodation today, Mullahs. My learned senior is on his legs. If it could be kept next week.
Respondent number 2. 2 to 4, my lord. You were there?
Yes.
All right. Last occasion, nobody was there.
We also have we've also served notice of fresh Mullahs. So I think.
Since the council is appearing, it's no issue.
Yes.
You want not today only?
Mullahs kindly keeps it on Thursday.
my lord. Tuesday or Thursday?
Mullahs, Thursday, Mullahs.
Thursday. Very well. By consent of the parties, list the matter on Thursday.
Grateful, Mullahs.
7th August.
Grateful.
Well, in item 2, the learned advocate general has taken the instructions, but he's on legs today. He has requested the matter can be taken up on Tuesday, Mullahs.
Very well. Tuesday.
But may it retain its position in
It
the
will
list.
be. It will be there in the list.
Grateful, Mullahs.
Tuesday.
I'm happy for the respondent, my lord.
The Advocate General is appearing when he is on his legs.
When?
Next week, but he told me any date next week.
I'm making it not today. Let us see.
But I'm for WBA this week.
Grateful.
There are 5 matters have been filed in the appellate side challenging the revocation act of where I had submitted all the incentive schemes have been revoked. The 5.
Which one?
This is also an incentive there.
Which one? 4?
3.
All right, 3.
They have already appellate side, they have challenged 5.
All right.
Ambuja had filed in Supreme Court. 3 or 4 companies have come before my lord.
When the matter is taken up, remind me. Otherwise, you say offhand.
My lord, may I just indicate? My lord, may I permitted to indicate, my lord?
4, my lord, I beg to appear on behalf of the respondent number 1.
I'm for the state respondent, my lord.
Petitioner is not here.
Petitioner is not here, my lord. He is supposed to file, my lord, exception to my
Lord,
report.
Today I am filing my report, my lord.
State report filed by the state.
Number 2 and 3.
Respondent numbers 2 and 3 in court today is taken on record. Copy served?
Just now.
Yes.
All right. For the respondent.
For the bank and the
Bank.
yesterday late hours it has been affirmed.
No, doesn't matter. But then petitioner is not here.
I will serve upon them.
All right. Let copy be served upon the
My
learned advocate representing the petitioner. Stop. It will be open for the petitioner to file exception to the report.
To the reports.
Who is the answering respondent?
My lord, respondent number 1. My lord, allegation is that, my lord, he has opened that bank account. That is not his bank account. That is the allegation.
All right. Report.
So, my lord, if that reports of the state.
Exception बोलना ना मैं की बोलना exception बोलना तो
open for the petitioner to file exception to the report.
reports filed by the respondents by 18th August. List on 25th.
My lord, only one thing, my lord, this report, my lord, if there is any implication against the respondent number 1, my lord, kindly, my lord, give me liberty to file exception, my lord.
That means respondent will file exception to the report filed by another respondent.
Interpreters.
Right. So what's going to happen? Just go through it.
There is
what happens.
They take a point that it has been signed by the petitioner. We send it to the QDB. The QDB report says no, it has not been signed by the petitioner.
It is, my lord, there is other accounts, my lord. Huge transaction is there, my lord.
More than 2 crores.
So report possibly will not be against you. It will be in your favor only. Next.
Grateful to you, sir.
My lord, I am for respondent number 225.
Lordship, I am for the respondent number 7, ICICI Bank.
Has reply been filed?
Yes, your lordship. They have given a reply.
They have given.
Lordship, currently they are enjoying a stay.
Interim order is there till.
Yes, in their favor.
Yes, none appears on behalf of.
My lord, I appear for the petitioner. My lord, could this matter be taken up on Monday, your lordship? My lord, I'm not well, could not come to court today, my lord.
I can see you are in your car and you say you are
Yes,
not.
my lord, yes, I'm
Then-
going to the doctor only, my lord, but I have to wear this
Where is the
because
bank?
to,
The doctor. They are
my
not.
lord, no, my lord, to appear before your lordship
Very
only,
well.
my lord.
Not
On
today.
Monday, my deeply obliged, your lordship.
Deeply obliged.
My lord, item number 6, I appear on behalf of the petitioner. My lord, I'm led by Mr. Bachawat. My lord, Ranjan
Your
Bachawat.
lordship, I appear, lordship, for the respondent number 2, your lordship. There
Please.
is already an interim order there, your lordship, and your lordship, we wanted to do the matter because, your lordship, our point is on the maintainability, your lordship, that this petition is not maintainable, your lordship. And your lordship, there is no stay on the conciliation proceeding, but nothing is being taken up, your lordship. From September, we are
Or
waiting
not
for it,
today
your lordship.
only.
My lord, Monday, my lord, not Saturday, Monday. If it,
Not today means Monday.
my lord, very good,
It's taken as Monday.
very good.
Your lordship, then kindly take it up on Tuesday, your lordship, Tuesday, your lordship, instead of Monday?
Please, lord.
Can it be Tuesday instead of Monday?
Just remind me in case it is called on Monday.
And he takes it up on Monday, my lord.
Why? What has happened today?
My lord,
Nobody is there.
My lord, I got heart in my leg. I can't stand more.
Monday.
Your lord,
Monday?
yes, yes, lordship, Monday.
Monday.
Thank you so much.
Obliged, your lordship.
Don't call any other matters. Nobody is there.
My lord, I appear on behalf of the bank, my lord.
Bank?
Yes, my lord.
SARFAESI proceeding?
No, my lord, I have not been instructed in this matter. My lord, Mr. Dipanjan Dotto is the leading counsel, my lord. He has instructed to appear, my lord. He's on his way, my lord. Only thing, this thing I have raised.
All right, let it be passed over.
Passport. Passport has.
Payment made.
Right, my left, please.
Please
Payment
take
has-
down. When was the payment made? Prior to the last.
No, after that.
After that. Answer. Learned advocate for the petitioner submits that the payment of the petitioner has been released. Stuff. In view of such submission, The writ petition stands disposed of. Same payment made.
থ্রি আছে আমাদের
দেখি file. Yes. Payment made.
Yes.
Same order. Your
similar.
Payment made. All right.
Number 5. Item number 5 for the petitioner. Petitioner has received the payment.
Received payment. Yes.
Number 5.
Payment made.
Only 2. Yes.
Payment made.
Item number 8.
Take your seat. Take your seat. Take your seat. Payment made? Yes.
Item number 9.
Payment made.
Payment made.
ওই দুটোতেই আটকে যাচ্ছে Number 10.
Payment made.
All right.
Item number 11.
Payment made.
Item number 12. Made. Payment made.
কি ছিল দেখি ফাইল
বলে ইস্যু করে দিয়ে যাবো 12 হচ্ছে
Payment made?
Yes. Payment.
None appears for the petitioner. Stop. Learned advocate representing the state submits upon instruction that the payment of the petitioner has been made. Stop. In view of such submission, the writ petition stands disposed of.
For the record, I'm just submitting the payment receipt also.
All right. Give. Payment receipt
Yes.
written with the records.
Okay. 12টা বের করুন।
13.
13 and 14 are lots of part payment made. There was a problem with, I will be very candid, there was a problem with our
All right.
part payment made. A fresh demand has been issued. It will be done.
All right. Learned advocate. None appears for the petitioner. Learned advocate representing the state respondent submits upon instruction that part payment has been made. Stop. The balance will be released shortly. Stop. In view of such submission, released on
After independence.
after Independence Day,
19, as per your lordship.
29th of August.
I'm so ready.
29th. 14 also same order. 15
15 is that, my lord?
Amount credited.
part payment.
Credited, but
14 is a part payment.
Yes. 13, 14.
13, 14 same order.
15 is that, my lord? Amount credited, but 60,000 has been, my lord, deducted, my lord.
Maybe
Without
for
it.
tax.
Your lordship, no. The composition, as your lordship remembers, the bills are reviewed.
Yes.
So whatever is admitted and it has been reviewed and found to be true and correct has been paid.
All right.
But the rest,
All right.
Noted.
I'll give leave. Learned advocate for the petitioner submits that a sum of rupees 60,000 has been deducted from the bills submitted by the petitioner for payment. Stop. Paragraph. Learned advocate for the state submits that the amount of 60,000 is disputed. Paragraph. In view of such submission, the writ petition stands disposed of, granting leave to the petitioner to initiate appropriate proceeding for releasing payment of the amount that stood deducted in accordance with law before the appropriate forum, if so advised.
Develop.
item number 16. আমাদের নেই।
16 আমাদের না।
Let me see.
আমার তো ফোন করলাম, আমি তো পাঠিয়ে দিই।
First day.
এইটা হচ্ছে সেই one.
None appears for the petitioner at the time of call. Stop. Are you there?
On behalf of the petitioner,
Item
16.
16? Yes, please.
My lord, I'm praying for a My lord, if we can keep this on Monday.
Monday? All right. কি বললাম? না, please take it in. Accommodation has been sought for by the learned advocate representing the petitioner. Released on 8th August. Service in the meantime.
Item number 17, my lord, amount credited.
Credited.
Yes, ma'am.
Same order as 12. Receipt.
Item number 18. Same, my lord.
Receipt. Same as 12.
Item number 19.
Same as 12.
Same.
Same as 12.
Same, my lord.
Same as
I am
12.
applying for the state, my lord.
Give your appearance.
22. Same, lord.
Same as 12.
Unnamed.
2, 13 and 14?
Yes. Yes. And 13 and 14, my lord, lordship.
Yes. All right. 23?
For the state lordship.
Yes. Payment made?
But see, where it to the instruction.
Payment made? No.
No. 17.
State? Why is payment not been made?
My lord, we are yet to receive instruction kindly. My lord,
Last week also they have made this same.
Yes.
Matter. 11 matters were there, my lord. These 5 matters only left. These 4 matters.
5 matters could not be disposed of. Pass over.
my lord, only 10 minutes possible will be enough, ma'am.
All right. Passing it over.
Grateful, madam.
23, 24.
Only 23.
Only 23, 24?
Grateful.
Who's there? Who's your other side? Let me see. These are all election payment.
Rituporna Laha. Rupornita Laha. Last week she was there, my lord.
She was there. Give a phone call. I'm passing it over. 25?
Urban state respondent.
Yes. Payment made?
No, my lord.
Why?
I'm giving instruction, my lord, no payment has been made.
Why? 24, passing it over.
What payment has been made, my lord?
না এগুলো হচ্ছে এটা আমি ঠিক কেন ফাইল হওয়ার আগে হচ্ছে
But this instruction will not suffice. Payment is to be made.
My lord, for your lordship's perusal, my lord, this order was passed on last week by your lordship, my lord.
Let me see.
Other matters, my lord.
Yes, payment has to be made. Here also. Please come.
এটা যেটা বলছি
Same order can be passed. Absolutely same. The same video also. Same order.
ভিডিও মাই
Same.
সেম ভিডিও
এই অর্ডারটাই দিয়ে দেবেন আর এই রিপোর্টটাকে না রেকর্ডে রাখবেন ইয়েস সেম ভিডিও হরিরামপুর সেম অর্ডার ওইটার please speak to your client. All right. Otherwise, the DM will be summoned in court. Payment should be made by the next date. I make it very clear. Order is already there.
My lord,
12th of September আসবে দুটো মামলা।
my lord, item number 23 and 24 will be called after 10 minutes, my lord.
As soon as your other side come, bring your other side. I'll
Biplab.
let me see. None for the petitioner. Stop. Released on 8th. 8.
Pay for the petition.
Who is your other side?
My lord, he called me last morning as well.
He
I
called
told him-
you.
Yes, I told him that.
Who is he?
That is what I did not get his name.
Your caller is not functioning? Huh?
Don't have to.
You didn't get his name? What do you
I
want?
have also served him a notice. Oh, Tapan Kumar Roy.
What do you want?
I have
5 lakh
28,
interest
29.
debit marketed from the
29. I
completion.
came with the 29. Oh, she's for
This is 29 or 8?
28
This is
Ratna Dash.
28. This is 28. Give him a phone call. You have his number? Call him up.
My lord, this is a she. He is here.
All right.
For item 29.
All right. Is it the same thing?
29.
Dekhi? Is it the same thing?
Yes, my lord.
Let me see your instruction.
The affidavit of service may be. And here completion certificate has been given to me, but dues are remaining.
Where is the completion certificate?
My lord, the completion certificate is at page 35. 35 and 36.
আগের যে অর্ডারটা করলাম না ওই সেম অর্ডার দেখিয়ে যেটা বললাম 12 সেপ্টেম্বরে আসবে। হ্যাঁ হ্যাঁ 24-25 কি ওরকম হবে অর্ডার যেটা দেওয়া আছে এটাকেও না সেম জিনিস করে দেবেন এখানে CMOH নন্দীগ্রাম report should be kept on record. I am posting it on 12th of September. An order is being passed. Please communicate. Let's see how payment can be.
Order is being passed directing them to pay.
Yes.
My
To
lord, only
let
one
them
thing.
come.
Only one thing, my lord. In respect of one of the work orders which pertains to Khodambari, it's a health center, health wellness center. Some payment has been made in respect of Khodambari. Remaining is
Prior to the filing of the writ petition, that
prior to
payment.
filing.
Only one payment to due.
Yes, some payment has been.
Whatever is
Some payment
due.
also
Whatever
made,
is left, my lord, I
Only
want.
one
Whatever
payment
is-
was due. Only one.
Whatever is left, you pay that. You do not have to make double payment.
Yes, yes.
Whatever is due,
That is
that
why
will be paid.
that is why I clarified this.
All right. Yes.
For the petitioner, my lord.
28 is passed over. Bring your other side.
Grateful, man. Petitioner.
30.
For the petitioner, man. My lord, this is tender matter. My lord, the amount is 25,38,381. I have complete
Completion certificate.
my completion certificate.
Are you ready with instructions?
My lord, some time may be given, my lord, because my lord, this is Purulia municipality is there, my lord. I've sought for instruction, my lord. They have not sent till now, my lord.
Purulia municipality.
Purulia
Are
municipality.
you there for the municipality?
Municipality, my lord.
You are appearing for the municipality. Then why is the municipality not giving you instruction?
My lord, only my lord, may this matter be fixed on 8th August, my lord. I will come up with the instruction. My lord.
Show me your completion certificate.
My lord, my work is order is on page 26.
Completion certificate.
Looking into it, man.
The petitioner alleges non-payment of dues by the Purulia municipality. Do you have the completion certificate?
Oh my lord, it's
Then
not there in the appended. It's not appended here.
the petitioner submits that. Did you receive any payment?
No, my lord.
No payment at
No
all?
payment. No payment at all, my lord.
The petitioner alleges that despite successful completion of work, comma, payment has not been released. Stop. A representation seeking release of payment is pending consideration at the end of the municipality. Stop paragraph. Learned advocate for the municipality is not ready with instruction. Stop. As it appears that the claim of the petitioner is pending consideration. Claim is a demand. At the end of the municipality, comma, accordingly, the instant writ petition is disposed of by directing the chairman of the Purulia municipality to take into consideration the prayer of the petitioner for release of payment in respect of the work done pursuant to the work order being memo number 2098 within bracket cannot read এটা দেখে নেবেন তো এমজি নাকি এটা I just cannot read শুধু 2098 লিখলেও হবে dated 18th of January 2017 issued by the chairman of the Purulia municipality in accordance with law at the earliest. In accordance with law, after giving reasonable opportunity of hearing to the petitioner for production of necessary documents in support of his claim at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If any amount is found due and payable, comma, steps shall be taken for releasing the same without any further delay. Stop. Paragraph. Learned advocate for the petitioner is directed to forward copy of the demand, comma, the demand and all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Deeply obliged. This is only one thing I would say. Petitioner would have solved the situation. 90% of the work has been done. While the tender was on, there was a direction from the chairman municipality that it has to be withheld. That is being the
Whatever is there, they'll give you a hearing.
consideration of the documents.
Yes. Next.
Great to know.
Lordship for 31, I'm led by Mr. Moyuk Mukherjee. He is on his legs in courtroom number 25 for a fixed matter 11:30. Kindly keeps it as a passover. He wants to do the matter, my lord.
Who is there for the other side? Are you there?
Lord, I'm for the university.
University. Who is the answering respondent?
Lord,
University. Very well. I'm passing it over.
Right, my lord.
32, I am for the petition.
Yes.
My lord, 2 lakhs and odd is the amount that is remain
How much?
2 lakhs and odd.
All right.
And my lord, I have given my vehicle for official purposes of the DI of school on the basis of work order. 2022 to 2018 onwards to 2022, it was given. My lord, the vehicle bill was my lord, generated by the DI of school. My lord, kindly come to page 30. The admitted dues that has my lord is specifically mentioned.
Three lakh 30,121.
And out of that, my lord, recently I got 1 lakh. 2 lakhs and odd is the due. Kindly come to the last annexer. I have made the prayer to the DI of school where my lord, the actual due as on date is reflected.
Page 32.
My lord, it is page 32.
Yes. Yes.
My lord, I informed the DIL, my lord, but till date they could not send
No
me
instruction?
no instruction.
All
my
right,
lord,
please
at
come.
any time, my lord.
The petitioner's payment on account of the
Hired the vehicle of the petitioner.
hiring charges of the vehicle of the petitioner
Page 24 onwards, my lord, the work order.
is due and payable to the tune of rupees 2,30,121. Stop. Part payment was made to the petitioner in the year 2022, not 21. 22 or 21?
My lord,
21 hyphen
recently, my
22
lord,
করে দেবেন।
2023, the 1 lakh out of
তাহলে
3
date দেওয়ার দরকার নেই। Part payment has been made. But the aforesaid balance amount is outstanding. Stop. Petitioner prays for releasing the balance payment. Stop. Learned advocate representing the district inspector of schools within bracket secondary education, Alipur, who hired the aforesaid vehicle, is directed to take steps for releasing the balance payment to the petitioner without any further delay, but positively within a period of 12 weeks from the date of communication of this order. Stop. The
my lord, I have made prayer for interest also, my lord.
do you have any other document apart from this?
My lord, that is the vehicle bill, my lord, is the latest document that I am having in my possession, my lord. And there is a specific mentioning, my lord, that this is the 3 lakhs and odd is remaining paid, and
yes, this
bank account has been given, the petitioner bank account. If my lord will consider once again, my lord, kindly page 30.
Yes, 30 I can see outstanding amount he has
3
admitted.
lakhs. And my lord, the bank account has also been given, and my lord, enclosure, copy of the original
12 months bills, all right. Yes. It will be open for the district inspector of schools to seek necessary documents from the petitioner in respect of the subject claim. Stop. Read petition stands disposed.
I'm appearing my lord 2 to 5. All
right.
My lord, regarding payment of interest, my lord.
The aforesaid respondent shall also consider the prayer of the petitioner for paying interest on account of the delayed payment of the legitimate dues of the petitioner. Next.
Affidavit service.
Yes, service is taken on record.
My lord, would my lord be kind to
1 minute, 33.
I briefly state respondent lordship.
Yes.
This is again supply of under the health scheme of the central government.
Which scheme?
Health scheme of the central government. Not there was supply of certain not hemoglobin test strips with hemoglobin meters in West Bengal.
Instruction.
Lordship, I look at some instruction from the client's lordship. I have not received any instruction.
Not received instruction. Is there anything to show that your bills are admitted or your completion certificate or something?
There is a complete at pages 89 to 99.
89 to 99.
Not the moment I raise the
tax invoice.
That's but the moment I raise the claim, they say they have to replace the entire lot after utilization of the same.
Because they supplied the damaged kits, your lordship.
No, you have
damaged kits are
supplied and utilized.
Agreement, and in that agreement, the arbitration clause is also there.
No, I said that whatever is due, whatever is found to be defective, if at all, because it's a manufacturer from Hyderabad, all over the country, same kit is being used.
Who is the authority to take a decision in the matter? Mission director or the somebody else?
Sir, please see only one document at page 111, 111.
Additional mission director, yes.
With respect to your letter number so and this office memo number so, it has been categorically informed to replace the entire supplied 17,370 HB meters along with 63 lakhs 95,370 new strips to be supplied, not consumed strips.
How can it be done?
63 lakhs already supplied. I am seeking for payment. I say that what part of it? I said what part of it has not been consumed? Please indicate that.
For medical purpose.
Consumed kits, my lord, can't
No,
be
no, not
replaced.
consumed.
My lord, what is my learned friend
Loss
saying?
happened due to the defective goods supplied by the agency. Is there any dispute redressal mechanism in your
But there is a
contract?
provision for arbitration.
Arbitration,
But not they say that we have got it tested through some laboratory which is unrecognized. But I
Alright.
say whatever be the consumed kits, pay for that at least, so that the rest can be done in the manner if there is a dispute at all. But all over the country, the same manufacturer is producing. But we are only traders. But there is no dispute across the country. Only in West Bengal this dispute has been raised. There are two manufacturers in the country.
Testing centers, Your Lordship, in NRS and also Calcutta Medical College.
And this is done only after the
and Kalyani AIMS, Your
done
Lordship.
only after the bills are raised for release of payment.
No, this is not
Pages
correct. Your Lordship.
89 to
This-
99, these
this
are the
is not
certificates
correct,
of
Your Lordship.
Who issued the work order? Let me see one.
Yes, please have a look at page 67.
Mission director.
Mission Director, National Health Mission and
Same
Social
person.
Security, Health and Family Welfare.
No, that is given by the additional mission director.
Additional.
And this is the
The same level
mission
probably.
director.
He is the additional mission director. This is the mission director.
There is a clause of arbitration, Your Lordship, in the agreement. Your Lordship.
But consumed articles for the arbitrator
And
will
will be
do.
decided in the arbitration.
What will an arbitrator do with regards to the
Dispute arises
consumed-
from arbitration agreement.
Would you like to go for a hearing before this authority and come back?
I took a very reasonable, I give a very reasonable suggestion.
I have followed it. You say that the kits or the goods which have been consumed, let payment be made. But
Indicate
their submission is that the goods that have been consumed were defective. How can payment be made? This is the
No,
thing.
that's not the submission. Please
That-
come to
yes,
page
this-
104.
This is my submission, Your Lordship.
No, if that is done, that's criminal for him.
What criminal for?
Yes.
Please come to 104.
Yes, there is a show cause letter for
Yes.
supplying.
This is with regard to the complaint received by this office regarding variations in the results displayed in the 8 images supplied by your organization. Many districts have also reported the issue of false result displayed by the supplied HB meters. There are only 241 of such which have been replaced. The such HB meters randomly collected from different districts were tested at the laboratory of KMC, Kolkata Medical College and Hospital, and NRS Medical College and Hospital in the presence of technical experts. And whereas the test results were found to be inferior and inconsistent with the results shown in the cell counters, and whereas it is found that the sample with lower cell counter reading showed higher value in HB meter, and similarly the sample with higher cell counter value showed lower reading in the HB meter. Example so and so. Then, whereas from the test results, technical experts have concluded that specificity and sensitivity of most of the HB meters are much lower than the prescribed value. Whereas these variations in results can be life-threatening, especially for pregnant mothers. Therefore, you are hereby
I do
instructed.
not think any hearing will also help because this is coming from the mission director.
Yes, not,
So the arbitration is the
so only
only
two
left.
things. Not, please see. Not, one is HB meter, the other is HB strips. But there is no dispute with regard to the strips supplied. HB meters could be showing a different result because of these had been lying in the godown. There was low battery, probably, I don't know. But so far as the strips are concerned, there is no dispute.
And
has not given
one
any
minute. Can this be differentiated, the meters and the strips?
This is meters not, your lordship has seen not when sugar is tested, a strip is provided.
Yes, yes.
Meter is the one which not machine.
All
That's
right.
the machine not which they are probably
Differently built.
Yes, yes, differently. These are in packets. The strips are in packets.
Yes.
Those have been utilized.
All right.
I have already supplied 1,67,000 strips.
But my lender friend has not given any reply to this letter.
Yes, yes, I have given reply. These are on record at page 106. There is no dispute with regard to the strips consumed.
Who is giving you the instruction?
State consultant law, national. State consultant law, national.
National Health Mission, my lord.
From the mission it is coming. Just inquire whether the strips which have been billed separately, payment can be made for that.
Those have been consumed. Not I.
And the strips have been consumed.
there is a meter which has a life of, say, testing 20,000 strips. The life will expire, or it may also give an intermittent result if the battery is low, depending on the frequency of the use. It's lying in the godown of the hospitals, I don't know in what sense. And the Asha Kurmis are utilizing it, going from door to door for the purpose of testing hemoglobin. Strips have been consumed, hemoglobin meters have outlived their utility insofar as these are
And
concerned.
this is not possible to give any payment, Lordship, because we have sent
Neither for the strips and not for the meters.
Lordship, because we have sent it for again testing to the Kalyani, Lordship. We received the report
Then
from there. Not available.
produce the report.
Yes.
When are you expecting the report?
How can a consumed strip be sent for testing?
Tuesday, Lordship.
All right, Tuesday is all right. For the meters, it is all right. But the strips which you have already consumed, then what is going to happen to them? They have been used.
Both have been tested. Both have been tested, Lordship.
And the strips which have been used, how can you test those?
Lordship, I coming with my report, Lordship.
Please come.
That's what I wanted to know. How many strips you have not consumed? Please indicate.
The petitioner seeks payment in respect of the HP meter and strips supplied to the National Health Mission. Stop paragraph. Learned advocate representing the state respondents is directed to file a report specifically disclosing the number of strips that have been used and the meters that have been used. Stop. The report shall disclose the number of meters and the strips which were found defective, if any. Stop. It shall be indicated as to whether payment for the consumed strips can be released in favor of the petitioner. Any further?
And meters, consumed strips and meters, not
at the strips and the meters.
Was only praying not.
Next Friday, Lordship.
No, I'll give you some more time. Don't worry. Don't jump. You bring a proper report with all facts and figures. Anything more, petitioner?
Only thing that I'm told that there is a threat to take action in terms of the contract after this.
So see, if there is it cannot be. Released on 22nd August.
My lord.
Second. Yes, affidavit of service to payment made.
Well, this is not a payment. This is an initial matter regarding the non-payment of security deposit.
All right. For a tender work?
Yes, tender work.
I am appearing for the respondent, but
This is Iloshi kindly come to my page 23, Mala. That is the Excel sheet, Mala.
Who is going to pay? Agro Industries Corporation?
Yes, Mala.
Yes.
my lord, I have received, my client received the application only on last day, and I received from them last day.
So she kindly come to page 23, Mala.
Please wait. Yes, page.
Page 23, Mala.
Yes.
Page 23, my lord.
That is the security deposit sheet, Mala.
Without any
10%, Mala.
Without any change.
The petitioner prays for releasing the security deposit.
My lord, this is without any
after successful completion of work.
No, my
Stop. Learned advocate representing the West Bengal Agro Industries Corporation Limited seeks time to take instruction. Released on 22nd August. How long do you want? 1 week? 22nd August. A report.
No, my lord, it kindly 22nd August.
A report shall be prepared and circulated by 18th August. Service is taken on record. Call the passover matter. Number one.
No. Item 1, I appear for the petitioner, my lord. Mr. Shuddha Sattva Banerjee is leading me, my lord. He's in courtroom number 6. He's on his legs, my lord.
Then I'll make it not today.
My lord, kindly makes it.
Very
today, my lord.
Item number 1, I was for the respondent. Right.
Take instructions and accommodation has been sought for the day, so it is adjourned.
But I have the instruction.
Very well. No, next day. 23. State. Petitioner was here. What is your instruction? Has payment been made and why has it not been made?
Portion, we have paid a portion of amount.
Give me your instruction. Yes. This is also Horirampur.
Yes, my lord. Same block,
Same block.
same order may be passed, my lord.
Total amount is 2,34,953.
Hmm.
We have sent the requisition lordship, but the amount was not there. That is why concerned department, we have sent it, concerned department for sanction of the amount.
Item number, same order was passed in item 25.
24 and 25, 26.
Acha, 25 and 26. Same order hobe etate.
Lordship, what is the order?
A report to be taken on record. Eta ferot diye din. Same report. Service. 12th. Ha, report ekta ache. 12th of September.
But will be paid.
Has to be paid. I am making it returnable by 12th. If payment is not made, the DM has to come. So make sure that the payment is made. Next.
24. 24.
Yes, your instruction, please.
Yes, lord.
Horirampur block.
Yes, my lord. Same block.
Same block.
May I hand over?
No fund.
Well, kindly see
Yes.
second page of the report, lordship.
No fund. Yes. I'm passing the same order. In case payment is not made by 12th, I'm making it returnable on 12th
Yes.
September.
12th September.
In case it is not paid,
Lordship.
the DM has to come and I do not know where from the payment will come. Everybody is getting payment and these people who've
Passing the similar order.
similar order. Same order, waiter. আগেরটা যা order হলো same order. হ্যাঁ।
28.
Deeply obliged, my lord.
20, I happy for the state, my lord.
Yes, please.
The sheet,
28 I appear for the petition.
but same thing, my lord. Kindly consider page,
So that was Horirampur block.
and the block is Nandigram. Lordship, may kindly come to page 3,
CMOH.
last paragraph, same thing.
Non-availability of
Not
fund.
update.
My lord, the affidavit of service.
Please come. Did you receive any payment?
No.
Nothing.
On instructions, my lord.
লিখুন তো, the petitioner alleges non-payment of fund despite successful completion of work. Learned advocate representing the state respondents relies upon the instruction forwarded by the Chief Medical Officer of Health, Nandigram Health District, dated 16th June 2025, which mentions that the requisition for fund has been placed, but payment can't be made due to non-availability of fund. Stop paragraph. As the petitioner appears to have completed the work successfully,
Page 41.
payment ought to be released in favor of the petitioner. Stop. The matter is made returnable on 12th September 2025. Payment shall positively made prior to the adjourned date. Service taken on record.
Well, report will be kept with the record, my lord. Grateful, my lord.
Grateful, my lord.
31, my lord, I'm appealing. My lord, pursuant to your lordship's direction, my lord, we have stopped.
Who is your other side?
I'm for the university.
Yes.
So no notice was served for before upgradation. However, I am
Upgradation, it was appearing, lordship sees, my lord, lordship's last order. It was appearing under the heading payment of dues, my lord. On the last occasion, it was taken up. My lord, that point.
Note, there was direction for service of notice.
Yes, I've served. I've served.
State government, not to the university.
And I've served. We see, my lord, this is Email, by way of email, my lord, also.
To the Raiganj University?
Yes, my lord.
Yes.
All right.
Lordship, see.
Check up, very well.
No,
What
there-
is your submission?
No, my submission is this, there are not the alternative remedies, your lordship kindly not produce this. There are remedies.
What is the remedy?
The facilitation council, Lord, then Lord, the mediation, then arbitration. Your lordship kindly produce the section 18.
Section 18, why? Where is the
18
work order? Show me the work order.
My lord, may kindly takes up page
No,
number 20.
Work order, I am placing your lordship, Lord, the micro, small and
I have
medium enterprise
successfully completed
development.
the work, my lord. 2 crores odd, my lord, are my dues, which are not being released by them. I have given them a legal notice on the 16th of June 2025, which is annexure P1, page number 14.
Disputing it, Lord, there are 3 projects.
On 16th
Only 2 projects.
Let me hear the petitioner. Page.
My lord, page 14 is my legal notice.
No, where is your work
My
order?
lord, page number 26 on, sorry, my lord, page number 20 onwards.
20 onwards?
Yes, my lord. My lord, first one is DPR for construction of Raiganj University, G+9 building with an accommodation of 20 departments and whole administration. My lord, that was the first one. This is dated 10th of September 2015. My lord, thereafter that page number
Page 20, which you are showing.
Yes, my lord.
The work order is of 2015.
Yes, my lord. Correct.
You had to complete the work within 90 days. You have filed the writ petition after 10 years.
My lord, I have filed the writ petition, my lord. Lordship may kindly sees, my lord, my legal notice once, my lord. The answers are there, my lord. If your lordship may kindly sees page number 14 once.
Yes.
Yes, my lord. My lord, I don't want to, lordship can go through it, my lord. The entire backdrop of the case, entire scenario, how they are saying that we have not charged as per what we are supposed to, how that has also been clarified and amount has been come to, my lord. I have reflected everything.
This reflection will not do.
My lord. Then, my lord, my lord, if your lordship so desires, gives me a day's time. I will take
statement.
A day's time will not save you.
My lord,
The petitioner is, the petitioner alleges non-payment of dues. Stop. A legal representation by the, on behalf of the petitioner is pending consideration at the end of the Vice Chancellor of Raiganj Municipality. Stop. Without entering into the merit of the claim of the petitioner, the instant writ petition is disposed of by directing the Vice Chancellor of the University to take into consideration the legal representation filed on behalf of the petitioner in accordance with law. After giving a reasonable opportunity of hearing to the petitioner and all other necessary parties, and pass a reasoned order. Stop. If any amount is found due and payable, the same shall be disbursed in favor of the petitioner immediately thereafter. Stop. Learned advocate for the petitioner is directed to forward a copy of the legal representation dated 16th June 2025 to the aforesaid respondent, along with all supporting documents at the time of communicating the order of the court disposed.
my lord, the exercise may be concluded within
12 weeks. 12 weeks, yes.
Deep brigade.
Number 35.
So in this matter, Mr. Shivaji Kumar Das is appearing as a petitioner, Lord. He is engaged in court number 6. Kindly note short password. Great. My lord, kindly make it not today then.
Not today?
Come on.
Tell him not today.
Neither I will be.
My lord, I wait to appear on behalf of the petitioner, my lord. By the order, Mr. Wasim is on his legs.
Yes.
By the last order, my lord has been pleased to direct the private respondent to vacate the.
Yes, yesterday he submitted that the keys have not been handed over.
My lord. My lord's order had not been complied.
And the private respondent is not appearing today.
No, my lord. Yesterday was absent and
Alright.
not appearing. The first direction was passed by your lordship on the January 16, my lord. Now we are in August, my lord.
None appears on behalf of the respondent number 7. Stop. Has any appeal been preferred against this order?
The appeal was preferred. That has
No,
been.
this one, 26th June.
No. I have no. To 26th of June, no. No appeal.
Acha. None appears for the private respondent. ঠিক আছে?
The petitioner want to enter into the property as your lordship direct.
Wide order dated 26th June 2025. The court directed the private respondent to vacate the subject property by 30th July so that the petitioners can enjoy the same peacefully and safely, free from fear of their lives at the hands of the private respondents. কতজন আছে একটু দেখে নেবেন তো?
And he will.
দুজন। Direction was passed to hand over the keys of the property by the private respondents to the officer in charge of the jurisdictional police station. Stop. Learned advocate for the state respondent submits that the keys have not been handed over to the police till date. Paragraph. The officer in charge of the which police station? Raiganj?
Raiganj police station.
Raiganj police station is directed to conduct an inspection to ascertain as to whether anybody is residing at the subject premises. Stop. The specific instruction shall also be taken as to whether the doors of the said premises are open or not. Stop. Inquiry shall be made from the neighborhood as to whether the private respondents reside at the said premises. Stop. Let a report be placed before this court.
My lord, the petitioners are unable to pay the rent, my lord, in Kolkata, my lord. They want to
go back
as early as possible, my lord.
Yes.
If my lord direct, they are ready to go back next week.
All right. Acha. On 6th August 2025. Let us see how soon it can be done. How many rooms are there in that house?
At the ground floor, my lord, there are the 2 rooms and 1 puja room, my lord.
All right.
And then 1 garage.
One?
Garage for.
Is a car there?
I don't
or is it vacant?
2-wheeler, my lord. And then that is
2-wheeler.
In the position of the.
Is the garage meant for the 2-wheeler or for a 4-wheeler?
That I have to know.
All right. Take instructions as to if the petitioners are sent back over there, where they will stay. That has to be taken care of.
They will stay in their own house.
Yes. All right. Come back on the 6th. Please see that the inspection is done immediately. All right.
Mr. Arjun Roy Chaudhary is appearing, Your Lordship, kindly praying for a short passover. He's doing a matter in court number 7, Your Lordship. Your Lordship, kindly for 10 minutes, please, Your Lordship, he's doing.
Very well, pass it over. Will you be the answering respondent?
My lord, I'm not the answering respondent, my lord. It is Indian Bank, I believe.
This is that matter, Your Lordship, where the PPF account is not released by the bank.
Who is your other side, the answer? Mr. Singh is there.
Yes.
All
Lordship,
right.
Lordship.
I'm passing it over for the time. Has it been solved?
No.
Lordship, it has been solved. Only Form G supposed to be put their signature. Bank official are coming on the way. Lordship, kindly fix it.
So
Pass it over. I am also coming physically.
New documents have been asked.
All right. Next.
30th, I am appearing for the petition. Pursuant to your lordship's last direction, I have served the office of the government pleader. This is the
Yes.
relates to non-payment of dues. My lord, 2 Work orders were issued pursuant to two notices inviting
Without
tenders.
prejudice to my rights, my lord, to place a judgment of 2021-10 SCC page 690, where, my lord, it has been stated by the Honorable Supreme Court that regarding tender matter, disputes were therein.
Is there a dispute?
There is a dispute, but my instruction is there is some admitted sum is due and payable. Now, if your lordship kindly have a look, the prayer first, lordship.
Don't go by the prayer. If I look
prayer-
at the prayers,
prayer
then
necessary.
90% of the writ petitions are to be dismissed.
Grateful to your lordship. Then, my lord, kindly have a look. What I want to, my lord, why I want to, my lord, look into this prayer.
Yes.
Because of the fact there are, my lord, the two scheme. Two scheme. And his, my lord, the demand with regard to his, my lord, alleged, my lord, the dues under that two scheme. Now, so far the documents, well, I have handed over to your lordship just now. Lordship, kindly have a look. So far the first document is, my lord, regarding my instruction. My lord, it is signed by video. My lord, it appears brief history of, my lord, that is, my lord, image DP, have a lordship, my lord. At the first NIET number, that is tender number, then 1103 image DP. Image DP is one scheme. Under that scheme, whatever the work order issued, that is revised work order and original tender amount, then work order. Then lordship kindly come to the fourth minute, একটা copy, submit a copy. Then my lord kindly come to received work order date, then status of work, total paid. It appears, my lord, total paid on two occasions.
3,40,140 is due because of unavailability of fund.
Yes. Now 3,40,143 is due and payable according to us. But because of non-ability of fund, what happened, my lord? The fund was available at one point of time. He could not complete the job within the time, and the fund, that is, my lord, then my lord went back. Then that is why we could not pay. So this amount we admit that 3,40,140, but the fund is not available. Now, if your lordship, my lord, it appears from the, my lord, the tender document that the district magistrate was, my lord, informed about the issuance of the tender. Now, another is, my lord, so far his another work order and the claim, the next document.
SFC.
Next document is SFC, another scheme, SFC. Here, my lord, including his SD money, that is security deposit money, it comes to 1,87,227. So whatever his claim in the writ petition, we only admit this sum. In the, my lord, in one scheme, that is 3,40,140. In another scheme, it is payable 1,87,227, including security deposit. Because in other schemes, security deposit already refunded. Here, security deposit retained, entitled to refund. So these two figures, my lord, if your lordship, my lord, kindly direct, my lord, I think, my lord, district magistrate is at the helm of the district, so that the fund can be made available, so that this can be paid.
My lord, only thing is from 2020.
Otherwise, my lord, the rest of the amount is disputed.
2022 onwards, representations have been made. This is coming up for the first time from their end. No reply or anything.
Whatever figures have been given to you.
Given to me, well,
Who's
I
come?
come back with the instructions.
The petitioner alleges non-payment of dues. Stop. Learned advocate representing the block development officer.
Arising out of, my lord, the
Mount
builder.
Gola -Roman 2 development block. Relies কি বললাম? No, learned advocate representing the state respondents received instruction from the video Mamunwola 2 development block that certain amount in respect of MSDP and SFC scheme is due and payable. Stop. The admitted dues cannot be paid because of unavailability of fund. Stop. The district magistrate Murshidabad is directed to take necessary steps for releasing the admitted dues of the petitioner without any further delay, but positively by 12th September 2025. Stop. Release the matter on 12th September.
In the meantime, make
Instruction retained with the records. Service.
Lordship, I appear for the petitioner. The respondents were directed to take instructions for the hospital where the disabled petitioner may be checked up. Lordship remembers the non-grant of family pension.
Yes.
My lord, I appear on behalf of the respondents 1 to 7. On the last previous occasion, we were asked to bring the list of hospitals. In the meantime, we have received instructions that the medical board was formed. On the last day, we had no directions upon it, but right now we were informed that the medical board has been formed on on 22nd of July.
This
Yes, 25.
the filing of the writ petition.
But still, we haven't received any instruction.
Where is the medical board so that the patient can go and get himself checked?
I have the give me. My lord, this is the instructions we have received.
I have not been communicated of any date of appearance.
I'm just I just have one copy.
Constituted a board on 22nd for checkup. Is the petitioner made aware that he is to go over there?
I have.
It doesn't appear so. The outcome of the board is yet to be known. Outcome of the board. So does it mean from here that you will accept whatever the Krishnanagar District Hospital reports?
Yes.
Very well. Please come. Learned advocate representing the Union of India. Relies upon a communication made by the accountant Nodia South. Accountant Nodia South.
This is the one.
This is the mail ID I can see. Who is the authority? Who has provided you?
Is there any written instruction?
That is only in the mail.
Relies upon a communication forwarded from the email ID accountant Nodia South dated 30th July 2025.
I know.
Mentioning that medical board has been constituted in the Nodia District Hospital Krishnanagar for examination of pre-existing disease for family pension claim on disability ground. Stop. Is the petitioner the patient?
Yes. The petitioner.
The petitioner is directed to make himself available before the medical board for checkup of his disability status. Stop. Hearing of the writ petition stands adjourned till 18th August 2025. Report by the medical board shall be placed before this court on the adjourned date.
May we be intimated by them that which is the date I should be present?
You should go and check up because I do not think they will be able to intimate you. They do not have the intimation. They only say that it has been constituted. And the board, take a copy.
I shall, sir.
Because the board possibly will not be available every day because various doctors assemble for the board. Right, so you have to apply with the court's order and see so that
somebody and see checkup then again because it is difficult.
If you want, I can adjourn it for another week also. Make it 25th. 25th of August because this will take some time. You also communicate so that the report comes to you fast.
My lord, I'm grateful.
I'm grateful.
Yes.
I'm appearing for respondent number 1, Reserve Bank of India. In this matter, my lord, on the last occasion, I had indicated that.
My lord, in this matter, I'm appearing on behalf of the petitioner, my lord. I'm led by Mr. Anirban Rai, my lord. I'm.
My lord, I think good. My lord, what has happened, my lord, here, my lord, after we filed the writ petition, my lord, the Reserve Bank of India is in a major hurry, my lord,
has sought to take actions on my complaint. But my lord, my prayer in the writ petition is for initiation of the insolvency proceeding. My lord, the order which has been passed, my lord, it's not in before your lordship, my lord. May I just have the liberty to get it on a supplementary affidavit? Your lordship keeps it on Monday, my lord. I will then, my lord, try and get to the matter, my lord. Because without that order, my lord, it will become difficult.
My lord, may I only indicate one thing?
My lord, I'll point it out,
Fallen from the
Mr.
petitioner.
Ray, that prayer was made last day. We had shown the documents of about prepayment.
I know, but Mr. Mitro, you have said something in court which I believe, my lord, what Mr. Mitra said, from that it would become evident that RBI should immediately initiate insolvency proceedings. And
My
that
lord,
is my
may I
prayer
only
in
indicate
prayer,
this?
my lord.
My lord, may I only indicate one thing? It has fallen from the petitioner that so far as after having initiated action and after having instituted this proceeding before this honorable court, that Reserve Bank of India has taken active steps and decisions, but that is not a fact because immediately on receiving the complaint from the petitioner on 26th of March 2025, Reserve Bank of India had sought for certain documents by way of email which was sent on 28th of May, asking for some details of the documents to be provided with regard to the communications exchanged with the respondent number 2, so far as petitioner's loan account is concerned, copy of loan sanction agreement letter, audited balance sheets for the concerned period, then also whether the company has reported the loan details to CIC, etc. But after receiving this email also, petitioner did not respond. Even thereafter, the Reserve Bank of India had acted on its own on the basis of the complaint and then looked into the accounts of the respondent number 2 and have found that the details after having received from the respondent number 2 that they have been making payments. And if there is no default on their part, then under the provision of section 45 MC of the Reserve Bank of India Act, my lord, the scope which is limited only to, I'll just indicate briefly to your lordship, if your lordship kindly looks at
File a
section
report
45.
in that case.
I can file a report, but
whatever
the
you've got to
supplementary
say.
affidavit which my learned friend is referring to and willing to bring before your lordship,
That
he
you
should
can
also
bring it on record.
Yes, I can also bring it on record that what exchanges have happened in the meanwhile, because only one thing before your lordship passes necessary orders. Section 45 MC is the relevant provision in this matter. Now 45 MC has got 3 parts. Now 45 MC says power of bank to file winding up petition. That is the bank on being satisfied that a non-banking financial company A is unable to pay its debt. It is under this very clause of the provision that this petition, writ petition has been filed. Now, if there is no default on the part of respondent number 2, then it is not within the domain of RBI also to file any action against it.
File a report.
So we will be filing necessary report to that.
The file a report, I will make submissions.
Whatever payment you
Document.
are making and everything.
We are fully paid.
All
Fully
right.
paid.
No, my lord, it has, my lord, let him file his report, my lord. kindly.
Likunta, the heard submission made on behalf of the parties. Stop. The respondent Reserve Bank of India and the non-banking financial institution are directed to file respective reports by way of affidavit disclosing all facts and figures. Stop. Such affidavit shall be prepared and circulated by
Give me 3 weeks. Give me 3 weeks because it's the department.
22nd.
22nd.
Exception may be filed by 3rd September, released on 15th.
Grateful to Lodge.
Very grateful, my lord, I'm very grateful.
Well, I am for the private respondent, my lord. Well, I think, my lord, this petition has become infructuous, my lord. Well, because
For the state lordship, led by Mr. Garib lordship, I am praying for not today lordship. Lordship, he is asked to straighten lordship the personal
infructuous.
yes, my lord, because my lord, petitioner challenged the notice under section 10(1) of the West Bengal Highways Act. My lord, thereafter, my lord, 10(3) proceeding was drawn up and they participated. And finally, my lord, 10(3) order was passed by the concerned SDO.
Very well. There is a request for a not today. I'll make it only not today.
Monday is monthly. Let it be on Tuesday, madam.
Let it remain in the list.
Great.
For the petition,
For the private respondent, madam.
Lordship, the petitioner is the joint account holder in respect of a cash credit loan account, Your Lordship. Suddenly, in the mid of November, Your Lordship, he comes to knows that his account has been frozen by the concerned bank. His account has been freezed by the bank, pursuant to which two representations have been submitted. One to the concerned bank, that is at page 12.
Very well, let me hear.
My lord, pursuant to this order received from the police authorities of Kerala Police, the subject account was frozen.
Till date, I don't have any communication of such.
It was
from the
communicated
police
over
authorities,
phone
not
that
from the concerned bank or the RBI.
the subject account might be the beneficiary of receiving certain fraudulent amounts. And that's the reason why the account has been frozen from November 2024 onwards.
And any particular amount?
No, my lord, this is it. This is all that.
It is the
only difficulty is that if we try to query the police authorities, they would try to develop, try to form a nexus between us and the petitioners. So we don't question that much. I mean, we have received this communication and thereafter we have frozen.
And it is a loan account, Your Lordship. The amount held, the bank is charging interest on that amount also.
Please come. The petitioner alleges that his cash credit account has been frozen by the bank. Stop. No reason has been disclosed to the petitioner for such freeze. Stop. Learned advocate representing the bank, Axis Bank, submits upon instruction that in response to a communication dated 1st November 2024 by the Kerala Police, by the Inspector of Police, উচ্চারণ করতে পারবো না, police station, Kerala, the bank account stood frozen. Stop. The police has disclosed that the bank account of the petitioner may be involved with fraudulent transaction. Stop. The case details and the notice under section 94 of BNSS and Bankers Book Evidence Act, 1891 is handed over to the court with a copy to the learned advocate for the petitioner. Stop. Paragraph.
I suggest you communicate over here.
It will be open for the petitioner to take necessary steps before the competent forum where the criminal proceeding is pending for defreezing the bank account. It petition stands disposed.
Regretful.
What is the appeal for the
Appear for the petitioners. I am led by Mr. Singh. I am only praying for a short passover. He's stuck in some different code.
What is the prayer? Are you aware?
Yeah, Milord, the matter is about 4 tenders. There's a
suit, my lord. Ideally, they should file a suit, my lord.
Let me hear. Yes.
Lord, this is about non-payments of certain work which was done and the performance notice was not issued. It's relating to 4 tenders.
4 tenders. Who is the tender issuing authority?
The Metro Railway.
Metro Railway?
Yes.
Are you there for the Metro Railway? Yes.
There are certain documents which Mr. Singh will be showing.
What document? You want payment?
Yes.
Where are your bills? Where are your bills? 93 lakh along with interest. Where are your bills? Have you annexed?
It's all there. Mr. Singh will be showing all the documents. I'm only
Please
paying for
show. Where is the completion certificate? Completion certificate. Not prepared.
In this petition, 4 different tax, my lord, had been linked to. And all, my lord, these contracts and contents and independent IA clause are arbitration clause, my lord. Yes, Lord, in all these contracts contents an arbitration clause, my lord.
Show me.
Lordship, it is, my lord, at page 50, my lord.
Do you dispute the work performed?
Lordship.
Did you intimate the petitioner about the dispute? Where is it?
Lordship, it is at development. Lordship, railway has a claim, my lord. It is at page 217, my lord. Lordship, counter claim of the railway, Lordship, I have made a mistake. It is at page 314, my lord.
What is 217? Refund of the license fees.
It is, my lord, at page 300, my lord, for
300?
314, my lord. আচ্ছা আচ্ছা দাঁড়ান। না না দাঁড়ান। This, my lord, pertains to the third contract.
Well, there are 4 tenders.
Yes.
Kindly comes to page number 79.
17?
9.
79. Yes. But if there is a arbitration, if there is an arbitration clause,
is there here.
Why will the writ petition be entertained if there is a dispute?
Well, Lord, I'm not the arguing counsel of this matter. I'm only on instruction to take a short pass over. Kindly short pass it over. Mr. Singh will.
Are you the advocate on record?
No, my lord.
Not the advocate on record even. Pass it over.
Obliged.
Right. 44 am for the petition.
The petitioner, who happened to be a very senior gynecologist, retired from the West Bengal Health Services in the year 2020. My lord, lordship may kindly take up page 21. My lord, the petitioner on his application was allotted a plot of land by the Asansol Durgapur Development Authority. My lord, page 21. There is no dispute with regard to payment of the consideration amount for the plot of land. Page 21. This was issued on payment of the amount, and thereafter, my lord, on 29th June 2024, next page, my lord, page 22, the remaining amount of 15,563 was paid. My lord,
Initial was 96 and there in 2020.
no, my lord, initially, my lord, page 21, 1,31,483.
Allotment was in 1993.
Allotment was in 1993. Thereafter, my lord, final payment was on 2004.
All right.
The remaining amount of 15,563.
Yes.
My lord, after this, my lord, due to various difficulties and primarily the petitioner was transferred to Jalpaiguri. There was a transfer to Ghatal. He had approached.
What is your prayer?
My lord, kindly takes up the show cause. My lord, that is in page, my lord, 23.
Presumption or what?
23, my lord, kindly takes up. The
delay in execution of the lease.
Delay in execution of the I was severely engaged in my government service, my lord, from getting transferred from one district to the other.
The show cause is long over. Then what happened?
My lord, I replied to the show cause, my lord, page 24.
Yes, then
since then, I am repeatedly sending them representations, asking them to register
after
the plot.
Show cause, no steps.
No
taken.
steps have been taken by them. I am ready
Right.
to register it, my lord.
Yes.
The state should consider my position at least.
Why state? Adda should consider it.
Adda, my lord, ADD.
This is, my lord, I say that this writ petition is not maintainable. The
Yes.
prayer, my lordship, is, it appears it's for a specific performance of contract. Once is
Contract has not been executed.
specific performance of the allotment, if that be treated as a contract.
No, you. What is going to happen to the after effect of the reply to the show cause?
Lordship, that needs to be disposed of, no doubt about that. But the writ petition, my lord, in respect of this contractual, my lord.
Series of representations after that, 26, 27, 28, 29.
The matter relates to execution of a lease deed in respect of a residential plot allotted in favor of the petitioner by the Asansol Durgapur Development Authority within bracket ADDA. Stop. Paragraph. In 2019, a show cause was issued to the petitioner. 2019, a notice to show cause was issued to the petitioner seeking explanation for the delay in execution of the deed of lease. Stop. The petitioner claims to have replied to the show cause. Stop. The petitioner alleges that since thereafter, there has been no communication from the end of ADDA. Stop. The petitioner is ready and agreeable to proceed to execute the deed of lease. Stop. Paragraph. Learned advocate representing ADDA is not ready with proper instruction. Stop. Next. As it appears that there is a reply to the show cause notice issued by ADDA and there is no final order thereafter from the end of the authority. Accordingly, the instant writ petition is disposed of by directing ADDA to pass a reasoned order in response to the reply filed by the petitioner in accordance with law. After giving a reasonable opportunity of hearing to the petitioner. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed. Grateful Lordship.
Well, the affidavit of service may be kept with.
55 my lord, I appear for the petitioner in this matter.
I am appearing on behalf of the state.
I am challenging an order passed by the district magistrate. Now, Lord, Paschim Mednipur. Now, Lord, the SARFAESI proceeding was initiated. This is a loan, Lord, amounting to rupees 101 crore as on date. The SARFAESI proceeding was initiated in 2015, and Lord, in 2016, Lord, this application was deposited, Lord, filed before the district magistrate. Where, Lord, 2016 to
application
24,
under
Lord,
section 14.
Section 14. But no order was passed. And Lord, certainly, my Lord, order was communicated on 4th of April 2025. And Lord, if your Lordship, my Lord, kindly comes to page 49, my Lord. 48, my Lord, the last paragraph, placing the order before your Lordship. Heard both parties, the opposite party admitted the taken up loan from the bank as per the revised affidavit dated 21st of January 2025. The authorized officer of the State Bank of India informed that OA number 314 of 2016 has been filed at DRT 3, Kolkata, and the SA number 401 of 2023 has been filed at DRT 1. Verified another case, wide number, CNR number, so and so arbitration pending before the learned additional district judge, commercial court, Jammu and Kashmir. In the said case,
Jammu and Kashmir coming over
Jammu
here.
and Kashmir. It's not binding on the district magistrate. The bank was not a party. The application was dismissed. That there was a status quo order, between the private parties, and the application was dismissed, granting the bank the liberty to file afresh after the completion of the proceedings before the Jammu.
No, I didn't understand. How come Jammu and Kashmir come? Verified another case.
Yes.
Another case means, is it related to this case?
Relating to the property, it appears, the case has been set up in Jammu and Kashmir between the private parties, where the bank was not made a party. That was taken cognizance of. There is an express bar under section 34 that the court, no civil court will have the jurisdiction to entertain any dispute, where there is a forum.
Then page 49.
Page 49,
Yes,
in the said
Honorable
case,
Judge.
the Honorable Judge has been pleased to pass an order dated 30th April 2024, which is as follows. Heard the learned counsel for the plaintiff applicant and also minutely considered the documents annexed with the plaint, as well, wherefrom it appears that prima facie case for immediate relief has been made out, coupled with the balance of convenience and irreparable loss factor in favor of the plaintiff applicant therein. Resultantly, issue notice to the defendants, non-applicants. Meanwhile, the defendants applicants are hereby directed not to create third-party interest in the immovable property shown in the commercial agreement dated 1st April 2023 between the party. The order is subject to objections from the other side. The plaintiff application shall serve a copy of this order upon the defendants non-applicants, along with the copies of the plaint, including the annexures, and file service of affidavit accordingly within 3 days. Verified case record of the SARFAESI and the CNR number so and so, and found Mouja Kharagpur are involved in both cases. With due respect to the order passed by the learned additional district judge, commercial court, Jammu SARFAESI case is rejected with a liberty to the petitioner to file afresh the SARFAESI application after dispose of the court case. Now, my lord, this, my lord, in my respectful submission, my lord, the district magistrate is only the exercising the ministerial power. My lord. He has assumed, my lord, the adjudicatory power by way of passing
It's
this.
not. He has relied upon some court's order. Have you checked up what the order is?
No, I have not been made a party, my lord. I do not know what has
Oh.
happened there.
Then please go through this order. Who is appearing for the private respondent?
But I appear for the pro forma respondent because I had purchased this property pursuant to sale proceedings and I have a sale certificate in my name. I'm supporting the petitioner.
I understand. But what is this? Did you take instruction as to what?
Lordship, we have carried out because I purchased the property and because of this order, I am not being able to get possession. My lord, we have checked up. We have been able to identify no records of this case. The concerned parties have refused to share any information pertaining to this case. I don't know how surreptitiously it was handed over to the Section 14 authority, who in any case did not have the power. Now, Lordship, there are 5 Supreme Court judgments. There's a judgment of your Lordship.
The ADM, he has not adjudicated anything. He has simply relied upon the civil court's order and rejected the case.
Lordship.
But then the court needs to know what is over there.
Now, my lord, may I make one submission just to assist the court, Lordship? First of all, Lordship, as per the law which is settled, I've seen judgments passed by your Lordship, also noticing all these Supreme Court judgments. The magistrate does not really have a discretion. The only task of the learned magistrate is to, really speaking, provide the police assistance. The only scope of inquiry of the magistrate is to see in the affidavit whether the particulars of the property are true and correct.
All right, please wait. Please produce this order. All right. The Additional District Judge, Commercial Court, Jammu and Kashmir, the order relying upon which the ADM passed order.
Yes.
Let this be, are you aware of it? What this order is?
I do not have any instruction received. To give some time. I will
All
come
right,
back
please.
with instruction.
My lord, I am only praying for a short date because I am out of the property.
I don't think short date will
My lord,
help
because,
you.
my lord, because this order could not have been passed, it's barred under Section 34. Now, let us assume if there's a valid proceeding also, that is absolutely null and void in view of Section 34 and 35 because these are all prior proceedings.
An order, even a bad order, remains good until and unless it is set aside by a competent forum, right?
Lordship.
So I want to see what it is, whether there is at all an existence of an order relying upon which the
Lordship. I'm only
ADM
praying for a
passed
short
order.
date, Lordship. Only a short.
Let it come. What is the date? This is 27 March. Acha dekhun. The petitioner, being the State Bank of India, is aggrieved by the rejection of the application filed under Section 14 of the SARFAESI Act by the ADM within bracket General Paschim Mendipur. Stop. The rejection has been made primarily relying upon an order passed by the learned Additional District Judge within bracket Commercial Court, comma Jammu. Stop. The petitioner is not aware of the details of the subject case. Stop. Learned advocate for the state respondents is directed to produce records relying on which the Section 14 application stood rejected by the authority. Page 48, please check up last 4 lines. Case number is mentioned. So everything must be there in the records of the ADM.
Yes.
Please bring those
My
documents.
lord, I have one more prayer to make on instructions. My lord, I am told, relying on this order, third-party rights are being created. The property sought to be let out to third parties now by the person in possession. My lord, that kindly protect, Lordship.
Wait, please wait. Released the matter on 13th of August.
Look, because in the meantime, Lordship, what will happen? Some protection, Lordship.
Let a report by the ADM be prepared and circulated by 11th August so that you all also get to know what is there.
Lordship. My lord, our only apprehension is using this in the meantime, they will let it out to some other party. Now that party will come and say, I'm a bona fide purchaser, and there'll be a
Cannot help, these complications always remain. I'm seeing so many of these things
Well,
in
but
these
there's a
SARFAESI
section
matters.
14 authority has no power to reject or accept. It's just to carry out the order. There's no other
I'm deeply
function.
2016 Milord proceedings and 2023 agreement Milord, that has been referred.
How is it possible, Lordship? I do not know, because grateful, Lordship.
But I am for the petitioner in this matter. My lord, I have served. My lord, in this matter, what happens, my lord, the petitioner gone into a contract with a video. My lord, your lordship kindly come to page 10 first.
Yes.
My lord, the work order has been issued to the petitioner, wherein, my lord, your lordship got it, page 10. My lord,
Payment has not been made. Payment has not been made.
payment has been made after,
Partly.
my lord, the administrative cut. My lord, they have estimated the sign by the BDO as well as the junior block plan engineer. Thereafter, when the payment has been made, my lord, the BDO has cutted 3 lakhs rupees from the 13 lakhs something, and my lord said it is
On
the
what account? On what account the money?
that is I don't know, my lord. What is the
Administrative.
administrative cut?
Last page, 28.
Your lordship kindly page 27, my lord, it cannot be
Yes.
from page 27 first.
Certified.
Your lordship kindly see
13 lakh.
certified that the last portion, certified that the work has been actually been done. So the gross payable amount rupees 13 lakhs 59,038
Released to the agency after
after being deducted
if any.
SD, IT, GST, everything, says everything. Now, my lord, the junior engineer block plan sign here. Now, when the payment has been made, area amount is such and such, administrative cut, rupees 3 lakhs. And
What does-
payment should be made 10 lakhs.
Right,
We
I have
don't.
followed. Yes.
Why? Because my lord, as per the inspection, he was supposed to construct road for about 516 meters. But there was previous construction which was existing, which he did not construct for during his tenure of work, was of 273 meters. So actually he constructed for 243 meters. Since the tender was floated for 516, but the condition was good, he did not construct, he did not demolish the other part and did not reconstruct. So he had to only construct for 243 meters. At that, for that reason, there was inspection by the administration, and as total sum of rupees 3 lakhs was deducted.
Then how can the engineer, junior
kindly see,
engineer,
my lord, this is-
he mentions that 30.
My lord, this is
Yes, this was with
my lord,
regard
only
to
only
the
one thing, my lord.
516 meters.
My lord, I am saying, my lord, your lordship kindly page 17 onwards. This is the first RA and final bill. My lord, running account bill. The RA means, my lord, running account bill. Your lordship kindly see.
Let
This
this
is
be
this is I have
by way
got.
of
I have got from by way of RTI. My lord, here each and every day, my lord, they have been made. Engineer has been made the cost. This is not my written.
If your submission is correct, then at page 27, how could
I
the
understand why.
junior engineer mention that he has performed the work and 13 lakh is due? He could have mentioned over there, no, it's only 10 lakh is due.
and
3 should not be there.
Even
also directs, let this be presented by
my lord, only one thing also, my lord. If your lordship kindly
You'll
come,
be trying to improve.
No, there's no question of improvement.
What exactly does this administrative cut mean?
Because at the final level, when the payment is being made, the supervising authorities inspect the entire thing. These junior engineers inspect on daily basis, on sign the logbooks and other.
So they are the better equipped with all details. They have the running account bills. They see what is being done. How could the BDO know that this work has not been done? There must be some document to suggest that this work has not been done. Then the junior engineer could not have mentioned that the entire work was completed. So
and
there
not,
is
not
something.
only so, one also, my lord, thing, my lord, if your lordship kindly come to page 10. Page 10.
Hmm.
My lord, first clause 5.
Yes.
Is clause 5. Estimated value of work put to tender 17 lakhs 14
lakhs.
such and such. Accepted rate 12.01 less. Thereafter, work order value 15 lakhs 8,822. Thereafter, when the work has been measured by the junior engineer, then this certificate has been given.
So it is less than the work order value also.
So, my lord, if
Total
that
value was 15.
Yes.
He constructed till 13 and you pay him 10 and you say 3 is deducted.
But at least the video should have the opportunity to explain why this was done.
Ajay, please come. The petitioner alleges that despite successful completion of work certificate issued by the joint junior engineer, block plan, Potashpur 1 development block, page 28, a sum of rupees 3 lakh has been deducted at the time of making payment. Allegedly, on the ground of, within single quote, administrative cut. Stop paragraph. Learned advocate. Administrative cut by the BDO Potashpur. Learned advocate representing the state respondents is directed to file an explanation as to why this administrative cut was made. Such affidavit shall be prepared and circulated by 2 weeks. 19th August. Released 26th. Exception in the meantime. Service taken on
but
record.
it will appear as upgraded version or my lord, the
Adjourned, not upgraded. Upgraded is the very first stage. Then it goes to adjourned.
my lord, father, my lord, the petitioner is.
No, you have to wait. See, otherwise other matters will not get a chance. Next.
But I am for the private respondent, my lord.
In this matter, I am appealing for stay.
The petitioner is the unfortunate mother, my lord, who has been a widow mother, my lord, who has been, my lord, driven out by his son and my lord, assaulted by his son. Now, my lord, what is happening in this matter? There is a landed property in favor of the, my lord, the petitioner's husband, my lord, who executed a deed of gift in favor of the, my lord, the private respondent, who is the son. After the, my lord, 2000, my lord, after the, my lord, he got the property by way of a deed of gift. My lord, initially, my lord, he take care of the petitioner. Now, my lord, 5 years back.
Did you approach the SDO?
Yes, my lord, SDO was approached, my lord, SDO passed an maintenance order, that is at page 32.
Yes.
My lord, my pair was, my lord, before the SDO was, my lord, for invoking of section 23 for, my lord, cancellation of the deed. But, my lord, SDO passed an order, that is at page, my lord, 32.
Yes.
They awarded, my lord, 10,000 maintenance towards the petitioner. My lord, with regard to the medical, my lord, the care, my lord, there is no whisper to that extent. And my lord,
but 10,000 is the maximum amount that can be paid.
For medical assistance.
My lord, he doesn't want also, my lord. But I am the unfortunate son, my lord.
Well, that has not been paid till date. Well, the amount was that is not been paid also, my lord.
Well, what does your son do? Are you aware?
No, that.
You don't, such type of mother, you don't know what your son does.
No, I am not taking instruction from my client.
My lord, I am unfortunate son, my lord. Well, my life has held, my lord, because of 5 sisters, my lord. I have never driven out to my mother, my lord.
Sisters have driven them out.
5 sisters, my lord. Was that their only
I have the photographs on how
father has given me, my lord, homestead land gifted to me, my lord. That is my only fault, my lord.
And I have no accommodation, my lord. I am
can you see the prayer A, my lord? He also doesn't want that rupees 10,000.
She doesn't want 10,000.
I want, my lord, for execution of the, my lord, the cancellation of the deed. Because after
what is your source of income?
My lord. The widow, my lord, nothing, no source of income.
And you are not accepting the money?
No, yeah, you were ready, my lord, accepting. We are not paid till date, my lord.
It is we. It is you.
My lord, he is not paying, my lord, till date, nothing. And my lord, I am, my lord, getting accommodation to my house. He, my lord, shifted me. He, my lord, shifted me to a cow shed.
But can his prayer only? He wants to set aside the order of the SDO. That means he doesn't want to see the prayer, my lord.
He, my lord, shifted me to the cow shed. My lord, after my 5 years back.
Who maintains the cows? Who maintains the cows? You are staying in the cow shed.
Yes.
Are cows also there?
Yes. Well, I have the photographs to that extent.
Who maintains the cows?
The private respondent, my lord.
He maintains the cows. And do you get the milk? You don't get the milk.
My lord, the condition, my lord, I have the photographs. If your lordship kindly, my lord, allow me, my lord, I will show how he cared my mother, his mother.
my lord, with regard to, I have the photographs to the extent.
I am ready, my lord. I have never taken her out, my lord. The sisters has taken her out, my lord.
My lord, I
Why
want,
should I? I am the only son, my lord. Why should I? 5 sisters, my life. has
after
become.
get the property from my lord.
And they forcefully.
What does your daughter do?
Daughters, my lord, I am in, my lord, taken care by the my daughters. Otherwise, my lord, I will be die, my lord. But the daughter has taken care of me, my lord.
Which daughter takes care of you?
Well, that is not, I am not.
Younger, probably younger.
My lord, you will also kindly come to page 28 once. My lord, the complaint, my lord. My lord,
Did you
that is the complaint of my lord, the daughter.
complain of the daughter? The mother has not complained.
No, mother is also lodge a complaint.
Oh.
That is that, my lord.
Oh, everybody has complained.
আমার মা
আমার
মৃত্যু শয্যায় বয়স প্রায় 81 বছর, কোন রকমের চিকিৎসা ও শারীরিক চিকিৎসা আমার ছোটদা গৌতম সামন্ত করছে না। উপরন্তু আমরা তার বোনেরা পরিষেবা দিতে চাইলে গৌতম সামন্ত ছেলে দীপ সামন্ত পরিবার আমাদের বিভিন্ন সময় তাদের বাড়ি থেকে তাড়িয়ে দিতে চায়।
Why don't you keep your mother in your place?
I want it, my
And
lord.
want
I
it
never did
and
I
keep
never did
in a cow set.
I don't know, my lord, what bold allegations, my lord.
I have the
I'll take
document.
care. I have
I saw
never.
the photograph, my
5
lord.
sisters has taken her, my lord. 5 sisters, my lord. My only fault is father has given
Pay the
tickets.
money. Pay the money. 10,000 rupees per month from the date of the order of the SDO.
Well, he doesn't want money. He want to set aside of the order, my lord.
I ready to pay.
Accept.
Yes, my lord.
My lord.
He'll accept it.
My lord, set aside the order of the SDO, my lord.
No, no, that prayer is not accepted. You make the payment first.
But I have given, my lord, something. Well, I have no means, my lord. I mean, agriculture, I have some agricultural land only, my lord.
Agricultural land. You do not
2.54
have means.
acres.
That means you do not want to take
No,
care
my
of
lord,
your
I want
mother.
I want it.
Well, he got
Let-
2.54
let
acre.
My mother come my place. I have never driven her out, my lord. They made a bold allegation.
No, but then what about the payment? 10,000 rupees.
I payments have made. Some payments have made. Payments
No,
have made.
some payments will not do. You have to pay from December.
It's paying, my lord. I'm paying.
Nothing, no, my lord, nothing, no.
Nothing. Show proof of payment.
Yes.
Right.
Please
my
show.
lord.
Very well, please come. The petitioner claims to be an octogenarian lady
No, my lord, I couldn't pay, my lord. I couldn't pay. 1 or 2 months I'd given her my instruction, my lord.
who alleges to have been driven out by her son. Stop. The petitioner approached before the subdivisional magistrate Ghatal, Paschim Mednipur. আচ্ছা, অ্যাপ্রোচের আগে একটা প্যারাগ্রাফ লিখুন তো। The petitioner alleges that after the petitioner executed a deed of gift in favor of the private respondent, comma,
My
she
husband of
has
the petitioner.
been
Executed. Husband of the petitioner.
আচ্ছা হাজবেন্ড আচ্ছা তাহলে কি বললাম, alleges that after her husband, since deceased, petitioner's husband executed a deed of gift in favor of the private respondent, comma, she has been driven out from the house. Stop. She is currently being taken care of by her daughters. Stop. তারপর হচ্ছে এই প্যারাগ্রাফটা, the petitioner approached the subdivisional magistrate ঘাটাল পশ্চিম মেদিনীপুর and vide order dated 12th November 2024. The subdivisional magistrate passed order directing the private respondent to deposit rupees 10,000 per month as amount of maintenance. Stop. The petitioner alleges that prayer was made before the subdivisional magistrate for cancellation of the deed of gift, as the petitioner was torturing. Now, petitioner, a private respondent was torturing the petitioner. Stop. Learned advocate for the petitioner submits that she is moving around from one daughter's place to the other, as she does not have a place to stay. Stop. Paragraph. Learned advocate representing the private respondent alleges that the complaint was lodged before the subdivisional magistrate at the instigation of her sisters. Stop. The private respondent does not have any objection if his mother stays with him. Stop. Paragraph. The upon hearing the parties, it appears that the private respondent is not paying the sum of maintenance as directed by the subdivisional magistrate. Stop. The private respondent is directed to immediately remit payment to the petitioner. How much will you pay? How much is due? From November, nothing has been paid.
1 or 2 months already.
No, he says nothing.
No payment was made.
No payment. So this is July 7, 8, 9, 9 months. 90 lakh rupees, 10,000, 90,000 rupees due. What not possible? Return the house, the landed property, the deed of gift, I'll cancel it.
It's a cultivator. It's no means.
In that case, I'll direct immediate cancellation of the deed of gift.
It's not possible.
Oh, you will not keep her. You will not.
Want him. I never.
Not wanting will not do.
I'll never divine her out, mother. I never divine her out, mother.
It cannot be. You cannot have both ways. Neither will you pay, nor will the deed of gift be cancelled. What can be done?
I want to keep her, my lord. What his father has gifted me.
No. What about you did not prefer any appeal or nothing of that sort. You'll be taken to custody now.
That has not been done.
You'll be taken to custody.
That has not been done.
What is to be done?
I'm taking, sir. That has not been done, my lord. No appeal.
When will you pay? And how much will you pay?
I'll have to take instruction, my lord, with it.
To the petitioner by 14th August. Stop. Release the matter on 20th August. Stop. Receipt showing payment shall be produced before this court on the adjourned date. Stop. It is made clear that in the event payment is not made, the court will be constrained to pass order for cancellation of the deed of gift.
At a time, not a part, my lord, sir.
Let me see your bona fide, then I'll think what is to be done.
And deeply obliged to.
Yes, my lord.
And deeply obliged.
50-এর পর পাসওয়ার্ড ডাকবেন।
ফাইল লিখে তুলে দিন। মামলা 90,000 পেয়ে গেছে। আরে ফাইলটা ও 90,000 পেয়ে গেছে, আর লাগবে না।
I'm for the state your lordship.
ফাইলটা রেখে চলে গেল।
My for a private respondent, number 9.
Dispute is going on between the petitioners and the private respondent since long over a plot of land which the petitioner has purchased. My lord, the private respondents they are not no way connected with the land in questions, my lord.
Then why they made a party?
For construction of a mandir, my lord, and they
Are you there for the state?
for the state. My lord, they are, my lord, encroaching my land. We filed a suit. There is a restraint order. You know, there are several, you know, criminal cases also pending. You know, police in action matters also filed. So the last occasion when before the, my lord, justice posed, my lord, when police in action matter was moved, my lord, you know, police submitted a report to reduce the dispute between the parties, my lord. One demarcation is necessary by the BLRO, my lord. They have referred the matter before the BLRO for demarcation of the land in question. My lord, till date, this thing has not been done. For this reason, we are unable to construct the boundary wall also. If your lordship kindly, this is my innocuous prayer. If your lordship kindly directs the, my lord, BLRO, my lord, to demarcate the land in presence of both the parties, my lord.
Show me the law which permits the BLLRO to go and demarcate private lands.
My lord, otherwise, my lord, how it could be, my lord, resolved?
Show me
This
the
is
law.
the problem. Last 2012, my lord, this problem is going
No,
on.
show me the law. There is a notification.
My lord, police has also, my lord, sent the proposal.
What is your submission?
I don't have instruction.
Why?
I need some time, my lord.
Why did you not take instruction?
I've asked for your lordship, but it hasn't come.
You have asked for? From whom?
From the concerned authority.
Who is the concerned authority?
দেখো এই প্রেয়ারটা দেখো প্রেয়ার এসো
Kindly come to the prayer of the writ petition.
No, you sought for instruction from the concerned authority, you said. Who is the concerned authority from whom you sought instruction and the same has not been provided? I'll call for that person. Who is the authority from whom you sought instruction?
Extremely sorry, Lordship, it's not that matter.
It's not done.
Lordship.
Do not make incorrect submission. I can understand.
Extremely sorry.
Don't do it. Don't repeat.
Extremely sorry.
What is your submission?
My submission, my lord, since it's a case of bail and error, my lord, there is a lack of jurisdiction, my lord, is
Why?
because it's a land matter.
Kindly come to the prayer of the writ petition.
Yes.
First prayer is, my lord, as regards to the demarcation of the land.
Yes, the prayer I've seen.
Prayer E.
Prayer
To
E.
the police authorities to forthwith render police assistance and protection to the petitioner.
Yes. You say it will be before the police bench. Private respondent says it will go before the land bench, where the matter is to be heard.
I'll come up with the instruction. Your Lordship. Kindly give me some time. I'll come back to that.
The petitioner. Where is the police report?
My lord, page 43. The relevant portion is page 43, my lord, last line. Last paragraph, last line.
42 onwards.
But my lord, kindly comes to page 43. 43, my lord, first paragraph, last line. A prayer also has been submitted to the BLRO Ghatal for demarcation of the said disputed land. My lord, if this land is demarcated, my lord, the entire
The police has submitted this.
During the course of, my lord, another.
Acha,
In 2024, Your Lordship, another writ petition was filed.
the petitioner seeks an order for demarcation of a plot of land in terms of the report filed by the officer in charge Ghatal Police Station on 20th December 2024 in connection with WPA 30080 of 2024 within bracket Joydev Kormokar versus the state of West Bengal and others. Stop. There is a dispute with regard to encroachment of private land. Stop. The police has opined that if the BLLRO Ghatal demarcates the subject plot, then the issue may be resolved. The learned advocate representing the state respondents is directed to revert with instruction. You get hold of that notification which permits the BLRO to demarcate private lands. Released 14th August. Yes.
Uh, 49, Lordship, I appeal for the petitioner.
Who is your other side?
Lordship, this is the affidavit of service. I've served the mentioning notice, post mentioning.
Who is your other side?
Lordship, it is the Union of India.
Nobody is here
Sir,
from the Union of
21
India panel.
The leave, Lordship, the petitioner number 1 is 39 years old and the petitioner number 2 is 56 years old. Just crossed the age for under the ART Act, Lordship.
Oh, this is under the ART Act?
Yes, Lordship.
Petitioner number 1 has crossed the age?
No, petitioner number 1, the wife is only 39 years. She is within age. Petitioner number 2 is 56 years, just 1 year above 55 years, Lordship. Lordship's judgment in this matter.
Give. None appears on behalf of the respondents. The petitioners as commissioning couple applied before the respondent number 4 clinic for obtaining the facilities under the, what is the name of that act is the Assisted Reproductive Technology Services. Start next. As the petitioner number 2/husband has crossed the prescribed age limit for receiving the service, the clinic has refused to provide the service to the petitioners. Stop. The aforesaid issue fell for consideration before this court in Shamoli Shaha and another versus State of West Bengal and others, and reported in 2024 SCC Online Cal, and with a judgment dated 22nd November 2024, the court was pleased to hold that the petitioners would be entitled to receive the facility under the act as the wife was within the prescribed age limit. Stop. In the instant case, the wife is aged 39 years and the husband has just crossed the age of 55. He is 66 years old currently. Stop. Paragraph. As the facts of the case are similar to the facts of Shamoli Shaha within brackets Supra, accordingly, the direction passed in the matter of Shamoli Shaha within brackets Supra shall also be made applicable in the instant case. Stop. The respondent number 4 is directed to provide the ARTS facility to the petitioners. Petition stands disposed. Service is taken on record.
Lordship, item 50 also I appeared for the petitioner. Lordship, this is a matter which will possibly require the Union of India's presence, because here, Lordship.
Your Lordship, I usually appear for the Union of India, so I can intimate the Union, Your Lordship.
Lordship, if your Lordship keeps it returnable, because here the petitioners have lost their 30 years old son in a disease which just commenced for 4 days. He died, and both of them are just the woman. The petitioner number 1 is just 51 years age, Lordship. She has lost her 30. Crossed. Yes, she is also crossed, and the father is also crossed. This will require some consideration.
In one matter, affidavit direction has been filed, direct given, isn't it? Was it your matter or somebody else?
Lordship is directed hearing of the matter, not.
There is no scope for affidavit, in fact, hearing.
So, Lordship will.
The petitioners intend to avail the benefit under the Assisted Reproductive Technology Act. Stop. Both the petitioners have crossed the prescribed age limit. Stop. Whether the said facility can be made available to them is required to be decided.
Here, may I beseech your Lordship only one submission, that since both of them have crossed without forming a medical board, possibly Lordships cannot consider at all, because it will be required.
It's open for you.
I have made a interim prayer for interim order to that extent.
No, you can make it on your own, because why do you want the court's order to undergo a medical test?
Lordship, because this will be an medical, unless a medical board is constituted, so see whether they are fit or not. Lordship, the private clinics will not issue that, because they possibly can't issue that.
Why don't these aged persons go for adoption? In the other matter also, I was thinking aloud.
I completely bow down, but there also there is the age bar. The age bar is there as well. I have consulted them. I have told them that you have lost your child. They do not have parents. But Lordship, there is also some, that is why, Lordship, this needs to be heard. I will also address.
Yeah, it has to be a heard, nothing doing. The matter is required to be heard. Are you there? Was Miss Pothra there?
Yes, Your Lordship, I'm there, Your Lordship.
Are you appearing in this matter?
No, Your Lordship, I'm just appearing for the union in the next matter, 51, but I can intimate the union, Your Lordship, regarding this.
Any day, Lordship keeps it returnable, I will.
Oh, but then I am not inclined to pass any direction for constituting a medical board or anything of that sort. This is to be heard.
Lordship, in one of the matters, in the Meghalaya High Court, Lordship, medical board was constituted. Thereafter, they were found unfit. Ultimately, the writ had no merit, Lordship. So, unless that exercise is exhausted, possibly hearing on the.
Assuming the report comes in your favor,
Yes.
then what's going to happen? That will not be proper. The legitimate expectation on their part will be, yes, see, I am capable of giving birth to a child, even then the court is not favoring. The law is against you, so I'm not inclined. Right? I can give you leave to get the matter heard. Leave is granted to the petitioner to get the matter heard before any other honorable bench having determination to hear the issue. Let notice be served upon the non-appearing respondents.
I'm obliged.
Call the Passover matter.
Lordship, before Your Lordship calls the Passover matters, Your Lordship, item 51, Your Lordship, I'm led by the learned ASG, Your Lordship. He's down with high fever. Your Lordship kindly gives us a short date in that matter, Your Lordship.
I am not taking 51, and it will not be taken up today. So
I'm grateful. I'm grateful.
Recover.
I'm grateful.
My lord, I am for the petitioner.
Yes.
My lord, it is that PPF matter with for the last 5 years. My lord, I shall draw your lordship's kind attention to the order.
Oh, you are here? I was just looking at.
Because my physical presence was very much required, Your Lordship.
My lord, kindly consider your lordship's order dated 15th May 2025 once, my lord.
Now tell me what is the new thing that has come up?
There are two new things, my lord. First, my lord, on 15th May, your lordship directed the bank, my lord, to file an affidavit disclosing the documents which are required to be filed. Now, then, my lord, on 19 June 2025 order, your lordship will find that they indicated 12 documents in the affidavit. And my lord, out of these 12 documents, my lord, I had shown that 11 documents I have already submitted. Only one document which was not submitted. Kindly consider, my lord, one paragraph of the affidavit. My lord, an affidavit, my lord, affirmed by one Ganesh Sinha, who is the bank manager, my lord. My lord, page 3, paragraph 2. That pursuant to the order dated 15th May 2025 passed by the Honorable Court in the instant writ petition, I respectfully submit before this Honorable Court that in order to release the money lying in the PPF account of deceased Subhash Mitro, as per banking norms and practice, the petitioner is required to fulfill the following formalities and documentations and submit the same with the respondent bank. Then at page 4, my lord, there are 12 documents. Only at the end of the page, your lordship will find para I. The authenticated audited balance sheet of the sureties. Now, this document, my lord, there is no mentioning of that which year. Since, my lord,
updated was the issue on the last occasion.
Yes, on the last occasion, I submitted, my lord, the updated one, old one as well as the updated one. Then my learned friend mentioned this matter before your lordship immediately on the next date. Then, my lord, my learned friend, my lord, submitted. They submitted before your lordship that two other documents are required. One is, my lord, the first one, provisional balance sheet. There is no concept of this provisional balance sheet. Second, a form. In that form, my lord, there are 5-6 documents which are mentioned in that form. Only this is the form. Your lordship, kindly see. This is a clear deviation from the affidavit which they have affirmed. This form says that several documents are required.
Succession certificate, letters of administration. Attested copy of the will, passbook of the subscriber, letter of indemnity, affidavit, letter of disclaimer on affidavit.
Now, if these documents are required, my lord, in the affidavit, my lord, they never said that these documents are required. Only they said audited balance sheets are required, which we have submitted 2021 as well as the latest one. Now, there cannot be, my lord, I cannot submit any document, my lord, a provisional balance sheet, which my learned friend, there is no idea. I do not know where from my learned friend borrowed this. And this form is not an innocuous form. It indicates so many things. Kindly consider this succession certificate or letter of administration, these were not mentioned. Now, this is, my lord, something, my lord, I will say this is a clear violation of your lordship's order, as well as, my lord, an undertaking, my lord, given by this court, and, my lord, it comes within the purview of section 2B of the Contempt of Courts Act. And undertaking given before the court, and this is, my lord, my learned friend is trying to circumvent this. Either this
All right, let me hear.
Let's say my learned senior friend has made so many allegations. On 23rd of July, your lordship was pleased to taken up the matter. And that relevant point of time, your lordship was pleased to direct the bank, since in terms of your affidavit, required document is already lying with you, except that indemnity and audited balance sheet, you're supposed to. And if you want anything more, mention the matter immediately tomorrow morning, so that bank may not deviate. Immediately, I've taken instructions from the bank. Bank was satisfied with the documents. The submission of the petitioner before your lordship is that the balance sheet for the year 2024-25 is about to be finalized in the month of September. They are not signed from submitting, but it is going to be finalized in the month of September. So the bank has requested him, very well, no issue. You do one thing, submit the provisional balance sheet, because the order sheet of 23rd July also mentioned that the latest balance sheet of 2023-24. So far as the release part is concerned.
Do not go into all these things. What is the problem? Tell me.
No problem. Today,
Pay the money.
Lordship, kindly allow me. This is, kindly see the bank in the direction of the Honorable Court. Your Lordship, without knowing anything, he has so many contempt, etc. I submitted before your Lordship. Kindly see. The authorities, in terms of the direction of the Honorable Court, has sanctioned. But in order to take that money, they're supposed to put their signature in the Form G, which Form G the bank will submit to the PP of authorities for disbursement of their interest, because they are thinking about their interest. The bank is also maintained their account for so many years that they will also reimburse interest from their authorities, but the authorities will not disburse until this Form G will not be signed. So far as the document is concerned, your lordship, the bank is saying the document they have, okay, if they do not have, the submitted document will taken into consideration, forwarded to the authorities, because if they want to take the amount, your lordship, kindly see, has been sanctioned. Kindly see the sanction date 30th July. Amount involved 95 lakhs and odd. We have to release in the favor of the petitioner. They have to acknowledge somewhere. It is not a general fixed deposit. It is a deposit under the scheme of government. The interest rate is governed by the central authorities. So when we are going to close the same, we have to submit this form. And they are reluctant to, we will not put our signature because it is not a direction of the
No, it is not only the signature. There are other documents which are to be enclosed. Are those documents required, or only signature will do?
Lordship. Signature will require. They are signed.
That your lordship.
So madam eager, we will not. Court has not said we will not.
My learned friend will come and say something else, my lord.
Sanction has been done, your lordship, which was not done earlier.
I am not passing any order.
Lordship.
I am recording this.
Lordship.
And I'm adjourning it till next Friday.
Lordship.
In the meantime, payment should be released.
Yes. So far as provisional, lordship, petitioner be directed provisional balance sheet, because
whatever you have.
Why they are signing?
Latest balance sheet I have submitted.
Latest balance sheet
Latest
submitted.
balance sheet.
23-24.
Yes.
24-25 not yet been finalized, but provisional, where is the impediment?
Income tax we have already submitted, my lord, the day we are
provisional. Have you submitted?
My lord, the final balance sheet.
95 lakhs they are going to has been sanctioned by the authority.
23-24, the balance sheet.
23-24. That is the last one.
Is it enough? 23-24 and money is there.
Because the authorities will ask. The authorities will ask. What can be done?
Enough balance
Yes,
is
yes,
there.
yes. Your lordship, kindly see.
Check up.
We are not disputing 23-24.
That is the latest one, my lord.
Want to see whether he has enough balance so that
Yes.
in case a claim arises, it can be met.
Lordship.
This is the idea.
Yes.
Right? If there is enough balance, then see the last one, 19 was given, then 23-24 is given. Check
Yes,
up and
yes.
see.
Lordship.
Because September has not yet come.
Not yet come.
They have not prepared the balance sheet.
Lordship.
Learned advocate representing the Indian Bank relies upon a communication dated 30th July 2025 addressed to Mrs. Shivani Mitro, the petitioner number 1, regarding settlement of the death claim. Stop. It appears therefrom that a sum of rupees 95,11,892.400 has been sanctioned.
Also, certain conditions here there. If their predecessor, if do maintain any
Subject to certain
Yes,
conditions.
yes.
Stop. Let a copy of the same be handed over to the learned advocate representing the petitioners in court today. Given? তাহলে লিখে নিন তো copy of the same. Let a copy টা যেটা আছে লেটটা কাটুন. Copy of the same has been handed over to the learned advocate for the petitioners in court today. It has been submitted that an application for withdrawal by nominees / legal heirs under the Public Providence Fund Scheme, 1968 in Form G is required to be signed by the
claimant himself, no?
How many are there?
Petitioner.
How many are there?
NOC was given by the other legal heirs. So only the
Alright.
petitioner number 1, Shivani
Alright.
Mitro.
By the claimant. Stop. The petitioners are directed to do the needful. Stop. Hearing of the writ petition stands adjourned till 8th August.
Grateful.
Obliged.
Your Ladyship, may I kindly request for one indulgence, Your Ladyship?
I believe, my lord, one point with regard to the maintainability of the writ petition is being, my lord, alleges, my lord, on the ground of existence of arbitration clause. My lord, I can demonstrate, my lord, many things before your lordship that arbitration, since it has been satisfactorily, my lord, it has been completed. I made a
Arbitration completed?
No, not arbitration, contract. They have certified.
No, but then if there is some dispute.
There is a dispute. Sorry. Milord, I say, Milord, in respect of one contract, they just ask me by a letter that you submit these 3 documents so that we can release the amount. Milord, the submission of the document is being made. Thereafter, one original is not lying with us. The original is misplaced. Police complaint are made. Milord, I made a representation. Let that be considered by them. If the dispute doesn't settle, Milord, we have to refer it before the arbitrator. Milord, we are not alleging anything, Milord, to be passed, Milord, in this writ petition right now.
No,
I made
that
a
is
detailed
all right.
representation to them with regard to my entitlement, which they have also not disputed. They wrote a letter that, yes, you satisfactorily completed.
Show me your representation.
Yes, Milord, that is page 93, part 1. Let this be considered by them. Thereafter, if this remains, Milord, we page 93, Milord, it's detailed representation, Milord.
Please come. The petitioner seeks payment in respect of certain works performed in terms with the contract issued by the Metro Railway. Stop. A legal representation by the petitioner before the General Manager, Metro Railway, is pending consideration. Stop. Learned advocate representing Metro Railway submits upon instruction that the there is a provision for arbitration in the contract itself. Stop. The petitioner ought to have approached in terms of the contract. Stop. Paragraph. Be that as it may, as a representation on behalf of the petitioner is pending consideration at the end of the General Manager Metro Railway. Accordingly, without going into the merits of the allegation and counter allegation of the parties, the instant writ petition is disposed of by directing the General Manager to consider the representation filed on behalf of the petitioner in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order. Stop. If the claim of the petitioner is allowed, then necessary remedial steps shall be taken. Consequential steps, remedial, consequential steps shall be taken. Stop. The steps shall be taken at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. It is made clear that the court has not entered into the merits of the claim, and it will be open for the aforesaid respondent to take a decision upon consideration of the representation. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation, legal representation, to the aforesaid respondent at the time of communicating the order of the court disposed.
Lordship, I only just wanted to submit that in the third contract, the railway has a claim, my lord.
Proceed with the claim.
But this is not the affidavit of service.
Yes, yes.
Grateful, my lord.
At the risk of being reprimanded by your lordship, item number 1, your lordship has adjourned it for the day. Instead of tomorrow, if it could be on Monday, not that much.
All right, I take it as not this week.
Very grateful.
Yes.
Item number 55 and 56.
My lord, may I submit?
My lord,
on the
before-
last occasion, after the conclusion of the hearing by my learned senior, a question was raised against me that whether I'm at all a party in this proceeding or not. There are two writs application, your lordship, pending before this. One is 18030 and one is 5368. In 18030, I was already made a party by order dated 16th August 2023. Thereafter, both these applications was running separately. Thereafter, the writ petition number 5368 was dismissed for default. Thereafter, it was restored. Both the grants were in respect of this 5368.
In 1803830, you are already a party.
Yes, my lord. And now another question was raised that whether we have filed our opposition or not. Until and unless my grant application 1 and 2 get disposed of,
That is in 5368.
yes, your lordship, I cannot.
But in 18030,
No, I'm not because when the order was passed to file a opposition, both the matter was clubbed together, and this matter was dismissed for default.
so what? The other matter was there.
Yes, absolutely.
So you could have filed an opposition if you have chosen to.
Sir, your lordship, my application, my opposition in regards to this and this, because we were actually trying to get my CRAN application disposed of so we can file together, your lordship. This is
That is your way of understanding. But then one writ petition, you are already a respondent.
Yes, sir.
And you could have filed opposition, and that writ is of the year 23. We are in 25. 2 years have passed. You did not choose to file an opposition.
Because after
Whatever is that, because it's your choice.
your lordship, after it was clubbed together, the matter was dismissed for default. Thereafter, I preferred a restoration application in regards to CRAN 1 and CRAN 2. That was allowed recently, your lordship. Let them serve. Let my CRAN application get disposed of. I can file my opposition by the next week.
Why are you not understanding that nobody stopped you from filing your opposition in that 18030?
I'll file.
Nobody stopped you. You chose not to yourself.
My lord, on the one thing, may I draw your lordship's attention that if he chose to file a affidavit in opposition after completion of our hearing, then we have to once again rehear.
Yes.
So for that reason, I'm saying, your lordship, my humble prayer is that my CRAN application may be disposed of. So can I again file both my opposition?
My lord,
together, your
there is a question of locus. We have already taken his locus.
Why do not you understand one thing? You already is a party.
Yes, your lordship.
You are a party in one matter. Why not file opposition in that?
I'll file next.
What you'll file? Hearing is going on. And all matters are heard together, analogously.
And he has already prepared a voluminous notes on argument, which is without affidavit. How that can be treated?
No, that has not been treated as, it has not been taken on record also. That has not been notes of argument. I never accept notes prior to the hearing being done.
Lordship.
So we proceed without your opposition.
Next hearing, I'll file, your lordship, my opposition.
Your opposition is to be dealt with by the petitioner. It's not that you can come anytime after a hearing.
Because
then in that case, you...
In regards to 5368 also, your lordship. I'll be filing my opposition because they have not served me the copy of 5368, your lordship.
Because you are not a party.
So that for my humble prayer is to get my CRAN 1 CRAN 2 may be disposed of, your lordship.
to dispose of your CRAN, I have to hear them because they are objecting to it.
Because my opposition will be filed on both the matters, Your Lordship.
I do not know. I am unable to make you understand.
Yes, I understood, Your Lordship. Understood.
I do not know.
My mate, please, Lordship.
Yes.
Kindly record that affidavit in opposition. Without affidavit in opposition, this hearing is going on. Kindly record.
What is there to record? If it is not there, it is not there. Was any direction given any time for filing opposition in that 18030 matter?
There is a direction.
And you chose not to.
They
Then
will-
nothing doing. It has to be taken that you failed to file the opposition. Yes.
But to remind your Lordship, my lord, very shortly, my lord, the facts of the case that all the cases, my lord, went to Supreme Court. This has got a civil flavor. It has been converted into criminal proceedings. And my lord, first civil favor, my lord will get it from the judgment of my lord Justice Sanjeev Banerjee at page 48 of Can 4. Starts at page 35. The relevant portion is page 48, last paragraph. Where my lord Justice Banerjee was pleased to impose a cost upon one of the opposite parties because of some fraud. Thereafter, my lord, it went to Supreme Court. Supreme Court initially quashed all these proceedings. Thereafter, Supreme Court again remanded back the 3 cases.
Yes.
With an observation, আমি just এমনি বলে যাচ্ছি আর পেজটা রেফার করছি জাস্টিস সঞ্জীব ব্যানার্জি হ্যাঁ পেজ 35 with the observation of the Honorable Supreme Court that since they are not otherwise settled, therefore there was a civil dispute which was converted into criminal proceedings. Now, my lord, before initiation of these 3 cases, the 2 cases, the petitioner sent 2 letters which are dated 22nd of August and 18th of September 2013, which are at page 58. 2 months later, Madam has already noted, the petitioner was arrested on 13th of November 2013 in connection with Shakespeare Thorny PS case number 397, dated 11th of November 2013. Under section 458 and 459. But he was not named in the FIR. He was not named in the FIR. And my lord knows it very well that omission of name in the FIR is a relevant fact under section 11 of the Evidence Act.
Yes.
Now, my lord, and I submitted bureau lawsuits on the other day that charge sheet has also been submitted under section 458 and 459. And my lord had gone through sections 458 and 459. Wherein, my lord, from reading of those 2 sections, my lord will find that the ingredients of the offense are totally lacking in the present case, and it cannot connect the petitioner in any way. Even the FIR is not alone. FIR is just the starting point, set the ball rolling. It, my lord, culminates with the submission of the charge sheet. I have gone to the entire charge sheet. The entire charge sheet, my lord, does not implicate the petitioner in any way. It does not touch. Rather, the respondent, the state, has put a nail in the entire case by showing that there is no allegation against the petitioner. He was not present at the time of incident. My lord has gone through it. He was a conspirator. who has orchestrated it. Now, what is the meaning of conspiracy? Conspiracy, the meaning of conspiracy is the meeting of two minds or meeting of other persons also. But there must be a cogent material to connect him with the alleged offense.
Yes.
But what is the then, my lord? Therefore, my lord, and lastly, there is a possibility of conclusion of trial in this case because there are 77 charge sheeted witnesses. And from the very beginning, my lord, we are claiming CCTV footage camera number 1, which has not yet been today, after 11 or 12 years, has not yet been produced and has not given with the observation of the learned trial judge. Let it be kept with the record, and that has been, my lord, described in page 12, 6, can 4 at page 65. At page 65.
Yes.
This is page number 397, which I had described here on the other day. Now let us come to my case number 340, the next case. Already I had submitted on the other day. Malad had taken note of it. In spite of this, I am reminding you of it very shortly. In connection with this present case number 397, you are sworn arrested in this case on 26th of November 2013. 340 was started on 16th of September 2013. After 2 months, after more than 2 months, he was shown to be arrested in this case. But strangely enough, I have shown to your lordships that there is no order sheet. There is an order sheet from 16th of September to 15th of November 2013. Order sheet starts from 16th of November, and this Miller did find it at page 89 of Can 4. I have already shown to your lordships. My lord, this is clearly a violation of section 157 of the Code of Criminal Procedure, which is a mandatory provision. A boy can do 157 টা দাও, খুলে দাও, আমাকে একটা কপি দাও, জাস্ট আগে বইটা দাও। কিছু নেই, তাড়াতাড়ি করো। দশকের দিনটা একটু আমাকে তো 157 The person against whom an order under section 458. এটা কি করছে রে? কোনটা? If from information received or otherwise an officer in charge of a police station has reason to suspect the commission of an offence which is empowered under section 156 to investigate, he shall forthwith send a report of the same to a magistrate. Forthwith means within 24 hours. Empowered to take cognizance of such offence upon a police report and shall proceed in person or shall depute one of his subordinate officer not being below such rank as a state government may by grant or special order prescribe in his behalf to proceed to the spot to investigate the fact and ascertainment of the case and if necessary to take measures for the discovery and arrest of the offender, and there are proviso. Therefore, the language is he shall forthwith. He shall forthwith. What is that compliance of mandatory provision? It was started on 16th of September. Order sheet is lacking from 16th of September to 15th. from 16th of September to 15th of November, there is no order sheet. We have taken the entire certificate copy from the record, trial records itself. The order sheet starts from 16th of November. How this is possible?
So the police officer is required to send a report to the magistrate, which should be reflected in the order sheet.
Definitely.
All right.
My lord has seen that. My lord has enough experience. Seen the FIR. Registered it. Police is directed to investigate the case. And what the officer in charge will do? Someone officer, SI such and such, is directed to investigate into the offence. It will be hence immediately, within 24 hours, would be sent to the London magistrate. There might be a delay. There might be a delay of 48 or 7. But police officer should assign reason, must assign any reason why there has been a delay of sending the FIR to the London magistrate. Otherwise, the Supreme Court says there is scope of manipulation. Now, my lord, it was initially started under section 147, 148, 149, 427, 317, 448. 560, 120B. Simply a case of theft. On the same day of prayer of 16th of November 2013, it was converted into 395, 397, read with 25, 27 of the Arms Act. I have shown your lordships on the other day how it could be made. Because, my lord, your lordships have seen the order sheet of page 89. Have a look at page 89 again. Page 89, the barcode. Wait. Page 89 too. Wait. Have a look at page 83. Page 83, my lord.
Yes.
Look at my lord. 16th November. This is the first order sheet. The case was started, my lord, on 16th of September 2013. And this is the first order sheet. I had shown you lordships on the other day. The prayer of the IO is allowed. Is different handwriting. My lord has said this might happen. My lord, I can, for argument's sake, I agree. But what is the application of mind? That I have perused the case diary. I have perused the case diary. Look at it, my lord, very minority. Therefore, there are reasons to believe there is something wrong, something fishy. Now, my lord, have a look at page 84 of this application of CAN 4 on Mr. Partho Chatterjee, who was the legal advisor of the present petitioner. He was also the maid accused. He made an application with the learned court on 11th of June 2009 seeking for some answer at page 86 to page 86. They could not offer any explanation. Page 86 to 86. Have a look at page 84.
Yes, 84.
On which day the sexual assault PSK number 340 of 2013 was sent to ARSDD. On whose order the sexual assault PSK number 340 of 2013 under circumstances was sent to ARSDD. Copy of general diary and date under which sexual assault PSK number was sent to ARSDD. Copy of the order of the superior authority for sending sexual assault PSK number circumstances was sent to ARSDD. So what are the answers? We look at answer at page 80, 85, 85 and 86. And kindly come page 8500. In pursuant to the above petition, I beg to state that as per the available record of sexual assault PS, the case was recorded as sexual assault, recorded by sexual assault PS such and such, 340. And thereafter, the investigation of the same was taken up by ARSDD. How it can be taken up by ARSDD? Because on the same day, my lord, it was converted under section 395, 397, without any application by the London magistrate. Now, my lord, section 379 is to be investigated by an ordinary SI of police, sub-inspector. The moment it turns into a case of dacoity, it will go to the detective department. By whose order? That we wanted to know. There must be a journal diary. There must be a journal diary. But it was done at the instance of Baidyanath Saha, Division Deputy Commissioner of Police, who wanted to grab the property. I am showing you the answer. What is the answer here? The case you are sent to the concerned department, and information is actually available as section as such. We are unable to provide the information as sought for. They are unable. Why? Why they are suppressing? এখন কিছু বলবেন না, please. Now page 86.
Yes.
Page 86. This is more strange. In pursuant to the above petition, I beg to state that the copy of the email message for sending the case is annexed herewith. The photocopy of the relevant page of the crime index is also annexed. No journal diary is at present available to furnish. The other details may be obtained from ARSDD Lalbazar is at present no further information available. Alright, what is the GD? No journal is available from the police station. It has been whisked away. How this can be possible?
State, please take note of all these, because you are to reply to this.
Lastly, my lord, I have gone through, my lord, each and every statement annexed with the charge sheet. There are no materials to connect the present petitioner with the alleged offence. My lord, strangely enough, the state could not offer any explanation whatsoever in any of the paragraphs of Can 4, so far case number 340 is concerned, excepting what are matter of record, matter of record, and what are written in the charge sheet. Only material, only they are saying it's a case of criminal conspiracy. But I've got two statements. I've got two statements. Those are, one is the statement of the driver of Mamta Agarwal, who was the tenant there, and one is the statement of Nur Islam of Rotondar Nahata, who was there occupying the premises, and upon whom Justice Sanjeev Banerjee imposed a cost of 500 gems at that point of time. My case is of 16th of September 2013. Have a look at the statement. But these are the two statements which they are showing.
Is it not part of the record?
Yes. Charge sheet.
Charge sheet.
Charge sheet. But this is not there. We could not annex all those voluminous documents.
All right.
It is just showing your lawsuit for primary satisfaction.
All right.
My lord will find, yes, the man was standing near the restaurant, Daylight Restaurant. Some persons went there and they found that the present petitioner And one person said, a white complexion man was giving money to the hooligans. That's the allegation. That's the allegation. Now, kindly see what is the date of recording the statement. Next page, my lord. Recorded on 22nd of November 2013. Reference গুলো বার করো। 22nd of November 2013. Case started on 16th of September 2013. After more than 2 months. After more than 2 months, 7 days. Now, my lord, this Pramod Kumar Sahu, the driver of Mamata Agarwal, was staying there at 9 in Short Street. It's close to Lal Bazar by walking 10 minutes or by car 5 minutes. But why there is a delay of 2 months, 7 days in examining witness? Supreme Court has said there might be a delay of 5, 6 days, 7 days. But there you must offer an explanation. In writing, not oral. If you cannot offer an explanation, it should be taken into account that you are a tainted witness, you are a tutored witness. You have come to cover the prosecution case, nothing more. But I am giving 2 names. One is my lord, statement of Pramod Kumar Sahu, kindly record it. Whose statement was recorded on 22nd of November 2013. 5/11/2013. And one is Nur Islam. Caretaker of Rotonlal Nahata, who was imposed a cost of 500 gems by Maharaj Sanjeev Banerjee for giving false statement to the court. Now, I am referring to judgments. Can you bear me for a moment? Reference is Balakrishna Swain versus the state of Odisha. AIR 1971 Supreme Court. 1971 Supreme Court, page 804. The head notes runs as follows. Then I shall come to the paragraph. Unexplained, unjustified. Head notes. Unjustified and unexplained long delay on part of investigating officer in recording statement of material eyewitnesses during investigation of murder case will render evidence of such witness unreliable. Now, the relevant portion I am reading. Paragraph 5 to go to paragraph. The relevant paragraph is paragraph 5. Well, just by that, 1, 2, 3, 4, 5, 6, 7.
I have got a different book. This is the SCC. You read, I can follow it.
Yes. Well, the observation of Supreme Court, the only other evidence is that of PW5, who was not examined till the 15th of January, till after 10 or 11 days of the incident. There was no reason why PW10, 19 could not have examined him because on his own showing, PW19 had met PW5 while he was going to the village when PW5 was being taken to the hospital. No doubt, PW19 says that PW5 was not in a condition for him to record his statement But apart from his saying, so he does not tell us in what condition period 5 was. Period 5 went to the Esama Primary Health Center, where Dr. Kanungo, period 22, who was a medical officer in charge, had examined him on receiving a requisition from the police. According to the doctor, 5 was under his treatment from 7/1/66. On examination, he found such and such. Therefore, my lord, period 5 was a vital witness. He was examined after 10 to 11 days. Period 19 got him, but did not record his statement. The Supreme Court found him unreliable. The delay of 10, 11 days. My case was at 2 months, 7 days. And one statement after 2 months. And I can tell you, I can doggedly tell in court that there no reason has been given by the prosecution as to why he was examined after 2 months, 7 days. Therefore, what value this has? Well, assuming for a moment that this evidence comes in court, comes in dock, I put him the question, can you deny this? That his statement was recorded on 22nd of November 2023. Then, my lord, it is an admission petition evidence. This is number one. My lord, second reference, मिलबे तो लो my lord, Guayadin versus State of MP. Guayadin versus State of MP. Both. 2006, one Supreme Court cases criminal. 2006, one. Supreme Court cases criminal 549.
It's 2005, 12 SCC 267.
Yes. 2005. No.
12 SCC 267.
Guayadin versus State of MP. Guayadin. G-A-Y-A-D-I-N. Guayadin versus State of MP.
Yes.
Bolo. I'm just reading the head notes. In an appeal against acquittal, High Court relying on circumstantial evidence and convicting accused under Section 302. Now, PWs who were examined to prove that the accused used to beat his deceased wife in spite of being available, not questioned by the IO within reasonable time. While one of them was questioned after 22 days, the other was questioned after 8 days of the incident. Hence, there was every possibility that they were planted witnesses. Para 5 and 6. Yeah, each of the Supreme Court cases. 5 Para 5, at the outset, it is to be stated that there is no direct evidence to prove the prosecution case. The High Court mainly relied on circumstantial evidence that there existed a bad relationship between the appellant and his wife, and he used to beat her, and that the appellant was last seen along with the deceased, and that he had set up a false plea of alibi. The counsel for the appellant and the counsel for the state drew our attention to the oral evidence adduced in this case. Period 12 and period 10 were examined to prove that the appellant used to beat the deceased Kasturi Bai. These two witnesses are neighbors, and they stated that they came to the house of the appellant and saw the deceased Kasturi Bai lying on a carpet, and she had been weeping and stating that she was beaten by her husband. Apart from this, there is no direct evidence as to what had transpired on the day prior to the date of the deceased. Strangely enough, these two witnesses were not questioned by the investigating officer within reasonable time. PW 10 was questioned about 20 to 20 days after the incident, whereas PW 12 was questioned by the police after a period of 8 days of the incident. there is no case these witnesses are not available in the locality during the time. I'm stopping here. Similar in my case. Yes. Attack.
Yes.
Therefore, my lord, my case stand on a better footing than those of two Supreme Court judgments. The last is criminal conspiracy. They're relying on this conspiracy, nothing more. And there are no other evidence by the prosecution. Well, what is criminal conspiracy? Well, I've gone through all the judgments. Well, Salisbury's laws of England. But I get the best. I get in every Supreme Court judgment so far as criminal conspiracy is concerned. It is totally there. The essence of the offense of criminal conspiracy is the fact of combination of agreement. The agreement may be expressed or implied, but in part expressed or in part implied. The conspiracy arises when the offense is committed as soon as the agreement is made. And the offense continues to be committed so long as the combination persists. That it is until the conspiratorial agreement is terminated by completion of its performance or by amendment or frustration of, or however it may be. The actors in a conspiracy is the agreement to execute illegal conduct, not the execution of it. It is not enough that two or more persons pursue the same unlawful object, the same time or in the same place. It is necessary to show a meeting of minds, a consensus to effect an unlawful purpose. It is not, however, necessary that such conspirators should have been in communication with every other. Therefore, it is necessary to show a meeting of minds. What is a meeting of minds? By these two statements of the caretaker and the driver of the opposite party, they want to say, or two or three more statements like this, they want to say that there is a conspiracy. But had it been recorded just one day after, had it been recorded just 2-3 days after, because 9 is short street to Shakespeare Shorny PS case, or Lal Bazar, the distance within 1 kilometer or 2 kilometers. But so far my walking experience is concerned, I take 10 minutes for 1 kilometer. At this stage, I don't know how much they have taken. They have taken more than 2 months. Now this is also what T40 is concerned. Therefore, there are no materials to connect me with the alleged offense of conspiracy. In both these two cases, they rely on criminal conspiracy. And there are, my lord, 42 witnesses, out of which one has been examined. One photographer has been examined, nothing more. But what are the others? Charge sheet has been submitted against 7. 3 are there. But the other 4 persons, the learned trial judge has not split up the case. The other 4 have not yet received the 173 papers, police papers. Then, after my lord's direction, they will get the police papers, they will appear before the court, and they will take another 20 years or another 10 years. Already 12 years have gone by in the meantime. In another 20 years. And next case of sexual chronic is minor. Case number 314. কোথায় গেল? Well, case number 314. Can put it outside. But this was started on 19th of August 2013. Just remember 19th of August. When he was in, since he was in custody. Since 13th of November 2013. In case number 379. But he was arrested on 6th of January 2014 on the strength of a production warrant, which is clearly after 4 months. Manad will kindly get it at page 21, page 23 of can 4. Manad got it. Therefore, the point is, Manad, why he was not shown arrested, although he was in custody since 13th of November 2013. Manad, charge sheet was submitted on 23rd of August 2013. Just after, Manad, 4 days the charge sheet was submitted. But he was not arrested. Although I am in custody in Lal Bazar. I mean, Lal Bazar sexual attorney is just a distance, but I could not be arrested. And my lord, it took 4 months. He was sworn arrested on the basis of a production warrant. My lord will kindly get 1 point, very serious points. If you, my lord, kindly excuse me, if your lordship, my lord, kindly take into consideration the writ petition number 5368. Main application 5368. বার করো এটা বার করো 5368.
Yes.
Page 15 para 16. Page 15 para 16. Page 15 টা বার করো। কোথায়? Page 15 para 16. I'm just reading, my lord. That in connection with sexual attorney PSK number 314 of 2013 dated 19th of August, the investigating officer Bhupen Rai, being respondent number 10, submitted a charge sheet with the code below, which was on the face of it perfunctory, incomplete and illegal. As in an undue hot haste, the sex respondent number 10, without an investigation whatsoever, and even without incorporating the names of father of other 2 accused, out of total 3 accused persons, submitted the purported charge sheet. Culminating an explanation was called for by the London magistrate from the said investigating officer, pursuant to such order of the said investigating officer, submitted a foreign report dated 17th of 2017, which reveals a deep-rooted criminal conspiracy of the unscrupulous police personnel attached to Sexual Authority Police Station. Kindly come to the annexure. Page 89 to 92. Page 89 to 92.
Yes.
My lord, page 89 is the first order sheet. Then, my lord, kindly come to the page 90 is the type is the court order, and written copy is the next page, the type copy. Does your lordship get it? That in absence of the original IO of the above case, the superior officer, Mr. Vishwanath Chaki, Assistant Commissioner of Police, ordered your petitioner to file charge sheet against the accused persons, and so hurriedly your petitioner filed the charge sheet against the accused person, but could not call the father's name of the accused person, and as such he could not give the father's name in the charge sheet. The petitioner filed an apology before the learned court. What is this, my lord? One is Vishwanath Saha, right, but now Vaidyanath Saha, another is Vishwanath Chakshi, as a commissioner of police. Within, my lord, 4 days, the charge sheet was submitted without the father's name, 3 accused persons without the father's name, and after 4 months, my lord, on the basis of a production warrant, he was produced. There is no explanation. There is no explanation. Again, my lord, there is an infringement of section 157 of the Code of Criminal Procedure. Again, on the next day, the case is to be produced with the court. But the order sheet starts from 6th of January. I kindly note it. Order sheet starts from 6th of January 2014. না এটা 314 এর কথা বলছি আমি। হ্যাঁ বলুন।
The case started from this one. Case started, what is the date of the starting of the case?
19th of August 2013.
19th August 13, and the first date order is?
6th of January 2024.
6th January 14.
When he was arrested?
He was arrested on 6th
On the
of
basis
January.
of a production warrant. Order sheet টা বার করো, order sheet টা বার করে দাও। এই যে পেজ দেখো। এই তো পেজ দেখো 23 বার করো। And 6th of January 2024 বলছি।
Order sheet, order.
হ্যাঁ 6th of January 2024.
Charge sheet was
And charge sheet was submitted on 23rd of August 2013. No, 14. 13.
and he was arrested on 6th of January 2014.
And he was arrested on 6th of January 2014. After 4 days, the charge sheet is submitted, and after 4 months, he is
Shown arrested on production.
on the basis of production warrant. My lord, therefore, my lord, now comes, my lord, from the plain reading which I have submitted very fairly before lordship, for a plain reading of case number 314, my lord, you find that there is a private case. But if your lordship find it, from our angle and from our, my lord, there is a serious infirmity which cannot be cured by anybody, and which is an absurdity. No prudent man can ever think of this type of illegality. Herein lies the case. If that be so, then, my lord, you must have to produce, whenever you are produced on the basis of production order, you must have to show the reasons for arrest and the grounds for arrest. Malad has seen, Malad, in various judges that these are two different components, two different concepts. Reason for arrest is another thing. But why I am taking into custody? Why I am produced with the court? There must be reason. That is lacking. That is totally lacking. Now, I shall show under the latest judges of the Honorable Supreme Court.
Yes.
There is no warrant of arrest. There is no prayer for absconding, that this man is absconding. my lord, since 19th of August. Because, my lord, it's a case under section 323, 324. The victim is going to the police station after so many hours. See, but there must be something. 19th of August, the date of arrest. After 4 days, 23rd of August 2013, charge is submitted. He is arrested on 6th of January 2014. My lord, it's a gap of 4 months. There is no warrant of arrest. There is no period for abscondence. Because he was already in custody. And what is the observation of the police? Hurriedly, I submitted the charge sheet by the superior, by the order of the superior officer. An oblique motive. There is an oblique motive to implicate the petitioner. Although this was the first case against him. Although this is the first case against the present petitioner. This case was kept in abeyance. Let us think that he must be implicated in more severe charges. Therefore, 397, 340 was started. And this was kept in abeyance with an oblique motive. But that's all. So far, my 3 Shakespeare Stony PS cases are concerned. Now, my lord, let me concentrate so far the judgments are concerned. And thereafter, I will come to the last case of Anandapur, that is a different category case. The judgment of. Judgment of what's the second? Oh, that's a complicated. Judgment is combination. First case I am citing 2024, just a copy of COVID broadcast to 8 Supreme Court cases. তোমার নিয়ে নেবে ভাই, তোমাদের স্টেটের প্রচুর পয়সা ভাই, কেন আমার করছে গরিব লোককে?
These are reported judgments. Why will copy be served?
2020 Supreme Court, 8 Supreme Court cases. 8 Supreme Court cases. 254. COVID broadcast versus State of Delhi. State of NCT of Delhi. State NCT of Delhi. Para 45 to 50. We are of got it para 45. We are of the firm opinion that once this court has interpreted the provisions of the statute in context of the constitution scheme and has laid down that grounds of arrest have to be conveyed to the accused in writing, expeditiously the said ratio becomes the law of the land. Law of the land. Binding on all the courts in the country by virtue of Article 141 of the Constitution. Now coming to the aspect as to whether the grounds of arrest were actually conveyed to the appellant in writing before he was remanded to the custody of the investigation officer. We have carefully perused the arrest memo and find that the same nowhere conveys the ground on which the accused was being arrested. The arrest memo is simply a pro forma indicating a formal diligence on which the accused was being arrested. Now, 48. it may be reiterated at the cost of the repetition that there is a significant difference in the fate, for which I have stated to your lordship. Reasons for arrest and ground of arrest. The reasons for arrest as indicated in the arrest memo are purely formal parameters to prevent the accused from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to investigation officer. The reasons would commonly apply to any person arrested on charge of a crime. Whereas the grounds of arrest would be required to contain all such details in hand of the investigation officer who is decided the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the accused all basic facts on his being arrested, so as to provide him an opportunity of defending himself against the custodial remand. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with grounds which are in nature. From the detailed analysis, there is hesitation in the mind of the court to reach a conclusion that a copy of the remand application in the public exercise of the communication of the grounds of arrest in writing was not provided to the appellant such and such as a result such and such. The next judgment is under 2025 Supreme Court cases online. 2025 Supreme Court cases online, Supreme Court, page 269. 69. Bihan Kumar, Vihan, Bihan Kumar versus State of Haryana. Well, can you have a look at the first page? Issue involved. First page. 4.1.1. Among the other issues, the main issue conversed by the appellant in this appeal is a violation of the appellant's rights under Article 22(1) of the Constitution of India, as the appellant was the informed of the grounds of his arrest. Now, my lord, para 4, 14, para 4, 14, 15, 20, 33. Now, para 14. Thus, the requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22 is included in Part C of the Constitution under the heading Fundamental Rights. It is a fundamental right of every person arrested and detained in the custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as maybe after the arrest, it would amount to a violation of the fundamental right to the arrestee guaranteed under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that, as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by law. The procedure established by law also includes what is provided in Article 22(1). Now, under paragraph 15 is the same thing. Remember that I shall not read, I shall wait my last time. All the petitions are same. But I should show you lastly para 33. This judgment will amount to the illegal detention so far the arrest is concerned, not the quashing of the entire proceeding. There are 33 speaks of that. I just show to your lordship. And this is my duty. Just all. Now next judgment is State of Haryana. Sorry. 19 goes to judgments. I should honestly state your law, speak to law, Mr. Bhattacharya and his judges to be have supplied me.
All right.
Because they are
Good that the juniors are working hard.
no madam, they are very good. Next judgment madam, 1992 Shafri within bracket 1 Supreme Court cases 335.
I can see one Bhajanlal already given.
Yes.
So I won't take
But
this.
just para 102.
102. এটা ফেরত দিয়ে দিন।
Just one thing I shall show to you. In Bhajanlal's case, para 5-7 kindly have it look at. Page para 102, para 5 and 7.
Yes. Right.
But the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. But I am showing to a lordship, so but the last case is concerned. Arrest after 4 months without any ground, thrown arrested on the basis of a production warrant and on the instruction of Vishwanath Chaki, the Assistant Commissioner of Police, he has submitted charge. And that's where the para 7. 102. While a criminal proceeding is manifestly attended with malafide and while the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Private and personal grudge. One is Mr. Shah, who is the Deputy Commissioner of Police, and one is Mr. Vishwanath Chaki. And there are no materials which the state has admitted except criminal conspiracy. Now, why I was in custody for 10 months? But can they take my liberty for the 10 months? Why they have taken my liberty for the 10 months? My family, my lord, was starving. Everything has been closed. I am suffering for the last 14 years.
What is the personal grudge that you say the
They wanted,
police?
They wanted property.
They wanted the property.
Only property. Because your lordship, I have told you, the order of Justice Sanjeev Banerjee at page 54 of the it is purely civil dispute. It was not a criminal dispute at all. Suddenly, Mala, they transformed into a criminal dispute. And what the Supreme Court said, if not otherwise settled, what are the reasons for Supreme Court to say this? To say this on the ground, in other cases, what the Supreme Court say? Your criminal appeal is dismissed. There is no malad observation. Here, Supreme Court says, if not otherwise settled. That means there was settlement. The settlement has broken, if not otherwise settled. The next point is And next is one of Chaturvedi which are for your losses. 1998 Supreme Court cases. Volume 7, 698. Maharaj already taken into consideration para 5.
Was it handed over earlier?
Earlier, then again I am handing over to you.
No, don't repeat, please, because duplication of copies will become difficult.
Why it would be, why the cases will be quashed at the preliminary stage. The page is again. Also should be 1998 7 Supreme Court cases 698. May it be jeopardized, take another copy. Para 5.
All right.
It can be caused at the initial stage, which paragraph 5 says.
Found it. Take it back. Yes. All right.
Then, my lord,
Yes.
2021, 5 Supreme Court cases, 524.
Copy not handed over earlier.
No.
Don't know. Maybe. First time. All right.
But this has been given to me by Mrs. Ghosh.
Paragraph?
Para 18.
Huh?
Then, my lord, 18.1, 18.2. However, at the same time, if it is found that subsequent FIR is an abuse of process of law, but the same has been lodged only to harass the accused, the same can be quashed in exercise of the powers under Article 226 of the Constitution, or in exercise of the power under Section 482. In that case, the complaint case will proceed further in accordance with the provision of the court. As observed and held by this court in a catering of decisions inherent jurisdiction under Section 482, under Article 226 of the Constitution is designed to achieve statutory purpose, that criminal proceeding ought not to be permitted to degenerate into a weapon of harassment. But this is my language, which I want to use. When the court is satisfied that criminal proceeding amounts to an abuse of process of law, or that it amounts to bringing pressure upon the accused in exercise of lenient power, such proceedings can be quashed. 18 to repeat the same matter, giving another judgment. Next, my lord. No, no. 2021 to Supreme Court cases 427. Manoranjan Goswami. What is a famous case? In which case of rape was against an editor. Para 63, 66 and 67. May I read para 63?
Yes.
The petition before the High Court was instituted under Article 226 of the Constitution and Section 482. While dealing with the petition on Section 482 for quashing the FIR, the High Court has not considered whether privacy the ingredients of the offence have been made out in the FIR. If the High Court were to have carried out this exercise, it would have been apparent that the ingredients of the offence have not privacy been established. As a consequence of its failure to perform function under Section 482, the High Court has disabled itself from exercising its jurisdiction under Article 226 to consider the appellant's application for bail. In considering such an application under Article 226, the High Court must be circumspect in exercising its power on the basis of the facts of each case. However, the court should not foreclose itself from the exercise of the power when a citizen has been arbitrarily deprived of their personal liberty in an excess of state power. Now, my lord, para 66. The power of High Court. In para 67, human liberty and the role of the courts. Now, my lord, Madhav Rao, now next is, I've got a this is a very remarkable judgment. 1988, one Supreme Court cases, 692. Amara Justice Monari Mohan Dotto, para 7. 1988, one Supreme Court cases, 692. Madhav Rao India. Para 7. The legal position is well settled when a prosecution at the initial stage is asked to be quashed. The test to be applied by the court is to whether the uncontroverted allegations has made prima facie established offence. It is also for the court to take into consideration any special features which appear in a particular case to consider whether it is expedient and in the interest of justice to permit a prosecution to continue. This is so on the basis that the court cannot be utilized for any oblique purpose, and where in the opinion of the court chances of an ultimate conviction is bleak, I can't take into consideration. And therefore, no useful purpose is likely to be served by allowing a criminal prosecution to continue. The court may, while taking into consideration the special facts of a case, to quash the proceeding. Where the chances of an ultimate conviction is bleak. But this is the point which I want to highlight with your lordship.
How many more?
Only one. Last. Article 21.
All
On
right.
to this case.
Yes. এই জাজমেন্ট গুলোকে না সব আলাদা একটা ফাইলের ভেতরে করে
1, Supreme Court cases 225. 225. Yes, yes. Thank you. তুমি তো সবই জানো ভাই। আর প্যারা 63, 64, 65,
64.
62 to 64.
63, 64, 65.
Yes.
62 also.
81, 82, 86, within bracket 8 and 9. Para 63. In Machandar versus State of Hyderabad, this court observed that while it is incumbent on the court to see that no guilty person escapes it is still more its duty to see that justice is not delayed and the accused persons are not independently harassed. The case, the court observes, must be held between the prosecution and the accused. The fact of the case, the court refused to order trial on account of the time or the display and the other relevant circumstances of the case. Now, my lord, para 65. Para 65. It is thus clear that even apart from Article 21, courts in this country have been cognizant of undue delays in criminal matters, and however there was inordinate delay, and where the proceedings were pending for too long, and any further proceedings were deemed to be oppressive and unwarranted, they were put to end by making appropriate orders. But I am suffering since 2013. Will be gone in the meantime. Chances of conviction are totally bleak. Now, next paragraph is 81. Well, this is in view of Article 21, 81. I shall not waste my last time. Now 82. The provisions of the Code of Criminal Procedure are consistent with indeed illustrate this principle. 86. Now 86, paragraph 8 and 9, subparagraph 8 and 9. This is very important matter. Ultimately, the court has to balance and weigh the several relevant factors, balancing test and balancing process, and determine in each case whether the right to speedy trial has been denied in a given case. Ordinarily speaking, when the court comes to the conclusion that the right to speedy trial of an accused has been infringed, the charges or the conviction, as the case may be, shall be quashed. But this is not the only course open. The nature of the offence and the other circumstances in a given case may be such that quashing of a proceeding may not be in the interest of justice. In such a case, it is open to this court to make such other appropriate order, including an order to conclude the trial within a fixed time where the trial is not concluded, or reducing the sentence where the trial has not concluded, as may be deemed just, equitable in the circumstances of the case. Therefore, so far our case is concerned, first case, 77 charge sheet witnesses. Nothing has been done. Second case, I was in custody, I was sworn arrested, there is no material to connect me with the arrest of it. Chances of conviction are totally bleak. Even the cameras have not been brought into picture. Nothing has been shown. Apart from criminal conspiracy, there is no material to connect me, and the statements were recorded after 2 months. The last case, my lord has seen all that. But that's why off. Next week, my lord, I shall finish the another case. Next week.
Next Friday.
I shall finish it.
All right.
We'll compile all the cases along with the written.
After completion of argument of all, then only. Yes. কি বলে? Learned senior counsel for the petitioner continues argument. Stop. Speaks for further argument on 8th.
My lord, আজ আমাকে একটু